Make please.
Items for delivery of order. Item number 25, contempt case civil 34 of 2024.
Some dismiss being time barred.
Okay.
Item number 26, bail application 2497 2025.
Will petition dismissed.
May it please the lordship.
Yes.
My lord, I beg to mention item number 9, my lord. I'm mentioning it in behalf of Mr. B. Protest, my lord. He has some medical emergency, my lord. He has flown out of the city, my lord.
Okay.
That matter can come up after vacation, my lord.
Mr. Dale, learned counsel appearing on behalf of Mr. Rukesto, learned conducting counsel for the petitioner, face for listing the matter after petition.
Deeply obliged, my lord.
May it please, ma'am. I beg to mention for listing a motion matter. Fact is that my appointment was cancelled by the deputy commissioner
When
Of-
we won
today.
today,
There's the urgency, my lord.
Court number
Yes, please, Lordship. Lordship, I beg to mention item number 2 of today list, my lord.
item 2.
Item 2, my lord. The engaged counsel due to some personal difficulty is unable to present today, my lord. So, my lord, I'm praying this matter will fix after vacation, my lord.
It was fixed for?
Huh?
Today it is in the motion column.
Yes, my lord.
Okay. Your name, please?
V. Baskor, my lord. V. Baskor.
B.
V. Baskor. Vinod Baskor. On behalf of
B.
NP.
Baskor, learned counsel appearing on behalf of
On behalf of NP Deora, my lord.
NP
NP Deora.
learned counsel for the petitioner. Press for listing the matter after vacation.
After vacation, after 16, my lord, if possible. If possible, after 16 October.
Okay.
Any date after 16.
27. 27 of
Fair, Lord.
May I please
Deeply obliged, my
oblige?
lord.
I beg to mention item number 18, Lord. 1818. On behalf of NJ Dutta. Yes, a person difficulty, Lord.
Okay.
Consent for others are already taken, Lord.
Mr.
I am KD Sharma.
K.T. Sharma, learned counsel appearing on behalf of Mr. N.J. Dutta, learned counsel for the petitioner. The counsel for the accused rests the matter after vacation.
May I please, Lordship. Lordship, I beg to mention item number 8, Lordship. Lordship, 8. Lordship, we are supposed to file an additional affidavit, but who don't file? We need some more time, Lordship.
Your name, please?
A. Islam.
Mr. A. Islam, learned counsel for the petitioner, submits that he could not file additional affidavit in this petition that due to some difficulties, and he pressed for listing the matter after vacation so as to enable him to file the additional affidavit. There is accordingly allowed. Let's submit the matter after vacation.
May I please, Your Lordship, I beg to mention item number 9. It may be adjourned.
9 already.
Oh, mention, no? Oh.
May I please, Your Lordship? I am for item number 7. Kindly the matter may be taken up after vacation.
After vacation.
Yes, as my senior has some personal difficulties.
Is your name, please?
Astanda,
Learned counsel appearing on behalf of
on behalf of SC Vishwas.
item number?
7.
No.
WPC number 73850 2020.
Learned counsel appearing on behalf of Mr. S.C. Vissas, learned standing counsel for the respondent of
Item
party.
today. Yes,
You inform the other side?
I am appearing for secondary education.
Any objection?
No.
With consent from the other side, press for listing the matter after vacation. Fair. Madam, did you inform the counsel for the petitioner?
Yes,
Whom do you inform?
Madam,
This
one
Yes.
is 6.
Huh?
And number 6.
Respondent number 6.
No, that's
Yeah.
all right. Whether you have informed the petitioner.
No, no.
So before mentioning the matter, you ought to have obtained consent from the other side, petitioner side. We'll call the matter then.
Okay, Lord.
Item for withdrawal, item number 27.
Basically, your lordship. Lordship, as per instruction, my client lordship, I want to do this petition with liberty.
Liberty?
With liberty, file fresh.
With liberty.
Okay.
Mr. MZ Shah, learned counsel for the petitioner submits that he has the instruction to withdraw this. Accordingly, it is dispose of withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate.
I have for
Yes.
all.
It's follow up for all the rest.
Items for motion, item number 1.
In this matter, previously it was sent to the judicial department for their views, and judicial department has returned that and now it is under the process of department. Ma'am. This is my application. Thank you. Yes, take it over.
Or is the copy?
Yes.
Again, this is Yes, sir. Yes, sir. It is instruction to see a otherwise instruction is only complaint where people are waiting. And it process will go to process to keep process. Actually, look into process of appointment is like similar the process will be how long they will take.
So after vacation then?
But the instruction, whatever is there, it is very incomplete, it seems to be, because well, they have returned, but what is the process? Whether he is going to appoint or anything, nothing in sense. Only saying that it is a process.
Now it is stated that same is under process. it is
Process or
under-
what, my lord? That should be, some specifics should be there.
What is the?
Maybe taken it as a
Not
positive
part.
way, my lord. Maybe taken it as a positive way.
I am
Under
thinking, but
process,
how long that will take, my lord?
So,
Lordship,
if
give it
there
a-
is some objection, then it may automatically raised by the judicial department, and then it would have reflected in the letter, my lord.
My lord, may I submit one
Uh,
fair,
sir,
So, my lord, after.
my lord, may I submit one fair submission, my lord? As per this notification, my lord, let them complete the process by within a specific date, my lord, that's enough, my lord. Why you are waiting for another time? Because whenever they are admitted, the process is under process, let the process be completed. My lord, fair
So,
submission.
4 weeks may be granted, my lord.
Hmm?
No, 4 weeks may be granted
for
for
Complete the
completion of the process. It is under the process,
so
my lord.
then, we are disposing of this petition. Right?
Like that way, my lord, lord may dispose of, my lord. Process mean, my lord, the property, my lord, the-
Not to discuss,
no, no, my lord,
my lord,
let me,
not
madam,
to
be fixed
discuss,
again,
my
my lord, let maybe list on that, but by this time they will complete. the
After
process.
vacation, it may be listed.
Yes,
my lord.
yes,
Okay.
yes.
Third, Mr. P. Counsel, learned counsel for the Mr. Sharma, learned subject of the responsible Secretary Education Department. So Sharma, learned counsel, subject counsel. In Secretary Education Department has produced a letter of the Joint Secretary to the Goksa Assam Department of School Education. And submits that the file has been endorsed. The file endorsed to the Judicial Department has been taken by the department. And the same is under process and he tries for granting him 4 weeks time to complete the entire process. Where is accordingly allowed, based on the matter on
On 24,
24th of October.
mass
The
of
letter published before the court
mass of
today shall be marked as Annexure Y and shall be taken to the report.
mass of
Item number 3.
May it please the lordship. This matter also for instruction, my lord. For instruction. Right.
Yes. Lordship, here in this case, Lordship, obtain instruction, Lordship, that I took. Wherein Lordship, no, yes, sir. Wherein Lordship, the department decided that to impose a penalty, Lordship, penalty of withdrawal of the pension for the first year of retirement, recovering the same from his future pension, Lordship. Now, Lordship, for this, Lordship, the governor have the power, Lordship, as per the pension rules, Lordship. And the approval from the before obtaining the before availing the power of the governor, Lordship, the APSC, approval from the APSC is necessary, Lord. We are submitted before the APSC, Lord. Lordship may issue the notice, Lordship, and kindly pick the matter after vacation, Lordship. In the meantime, Lordship, the state actual status may be come out from their end, Lordship.
Okay, heard me, sir?
I'm sorry, my lord.
So I can learn it. Sir, take it with something, learn it.
Lord, standing counsel.
Respondent number 1, with 4. And Ms. Borua for respondent number 3. As tried both that they can cite that department. He said that I think subject or by not within 12 1 It is to be noted here that by order dated 22nd of September 2025, the Goswami learned Sending counsel for the respondent number 120. No, 2 and 4 was directed to obtain instruction as to the status of the representation filed by the petitioner. In person to the said order, Mr. Sami has produced a letter of the Deputy Secretary to the Government of Assam Animal Husbandry and Veterinary Department, and advised this court that the Animal Husbandry and Veterinary Department has decided to impose the penalty of withdrawal of pension for the first year of the retirement, recovering the same from the future pension in respect of the petitioner. And in order to impose such punishment, approval from the APSC is required, and the department has already submitted the proposal to the APSC. And at this instance, Mr. Goswami submits that notice may be issued to the respondent, and he will bring up to date status of the representation filed by the petitioner hearing after vacation. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. However, it's a requisite copy of the petition be furnished to them during the course of the day. In the meantime, Mr. Goswami, the learned standing counsel for the respondent number 1, 2, and 4 shall file the affidavit in opposition. The letter produced for the court today shall be marked as Annexure A, shall be tagged with the record. This after petition.
My lord, can you fix it there, my lord, after vacation?
29 October.
Lovely.
Item number 4,
May please, Lord. Passator for time being, Lordship. Here we are preparing another.
Item number 28.
May I please, Lordship, this matter will be taken up after some time, my lord. My seniority and late. Of lord.
29.
May it please your lordship, my lord. My lord, here, my lord, the petitioner is, my lord, was appointed as assistant is, my lord, her initial appointment order is a page 22, my lord, annexure 1. 13/10/1991, initially at Gozal Bosti, LP school. Then after, my lord, by order dated 14/10/1991 at annexure A2, page 24, my lord, she was allowed to work in, my lord, number 2 Gulimora LP school. This is the school, my lord, in question here in this case, page 24. My lord, 14/10/1991. Since then, she is working there. My lord, my lord, this next, my lord, annexure 26, she has been confirmed in service, my lord, as per rule 4 of the Assam Elementary Education Provincial Service Rule, my lord, 1981. My lord, yes, confirmation as per rule 4, my lord, of the 1981 service rule. So confirmation made, my lord, kindly see, my lord, serial number 6, Momta Ghosh, the petitioner, my lord, number 2 Gulimora LP school. So confirmation has been made in this school, my lord. Now, earlier also there was a move for transferring her out, page 42. And she was directed to hand over search to the block elementary education officer because and this order was put to challenge before this honorable court, page 44, my lord. And there was a direction for stay of the impugn order. And pursuant to this direction, my lord, at 16/10/2023, my lord, pursuant to the stay order, they have cancelled the order, impugn order, that then issued in 19/9/2023, my lord. Now, my lord, here in this case, she has been working since 19/5/2018 as head teacher, page 27, my lord. My lord, the impugn order now they has passed as page 47, saying that there is some instruction by the, my lord, the CMO office, and the attachment has been directed to be, those attached posts has been directed to original post. Now, my lord, in view of confirmation, page 47 is the impugn order, my lord, 29/2025. Now, whether I am in the attached post, my lord, in view of my confirmation in service, page 26, my lord. So, in my case, on my humble submission, after confirmation, attachment does not continue as per rule 4. So, in view of my confirmation in service, they cannot say that you are still in attachment. So, this order is under challenge, my lord. This order 29/2020 we receive on 22, my lord, and file the case on 24th, my lord. Rule 4, my lord, may take into account, my lord, for a moment, my lord. Itu দিব নেকি দাদা? Confirm কৰিছে। Rule 4. The confirm in service.
Yes,
My lord.
page number
rule 4, that this is the book, my lord, here. Assam Elementary Education Provincial Service Conduct Rules 1981.
You tell me the page number.
The 313, my lord. Confirmation. My lord, confirm, subject to ability of permanent vacancy, every member of the service shall be confirmed in the cadre, class, grade to which he is appointed substantively. If he or she has completed at least 3 years of continuous service after provincialization, he or she has successfully undergone a necessary training as may be prescribed by the Department of Facilities for which he has been offered to him by the department during the 3 years, provided that these teachers who have completed 45 years of age, petitioner is 57 years of age, or have completed 3 years of continuous service after provincialization, but not facilities have been provided to him or her for the prescribed training will be confirmed, provided there is nothing adverse against him. As per this page 26 has been issued, my lord. My substantive post is in the number 2 Gulimora LP school. So they cannot now say after confirmation that I am still in the attachment. So therefore, the impugn order, my lord, is under challenge. And I have a prayer for stay also, my lord. Did get that. 7:15. Yo. But I have made a statement also, my lord, that this has been made only to accommodate my junior one, my lord, working in the school is para 16, my lord.
So for what?
Yes, 20.
Lord, sir.
Confirm only.
Originally, you have been appointed in
My lord,
LPs.
Gozalbuzi, my lord.
Thereafter, you have been
Thereafter,
appointed.
on the next date, my lord, they have, my lord, allowed me join in, my lord, number 2 Gulimora on 14/10/1991,
Where is
page
that order?
24.
Where is that order?
My lord, page 24, my lord. In the interest of public, Mamata's assistant teacher LP school hereby allowed to join in the number 2 Gulimura LP school where there is no assistant teacher. Till revocation of this order, you were allowed to receive salary in the school wherein you were appointed. Original, I have given page 25. Now, from then, my lord, 14/10/1991, I am continuing there. And while the headmaster of the school, my lord, retired in 2018, on 29/5/2018, I have been given the charge of the school as headmaster, my lord. That charge is given, my lord, page 27. Now I'm continuing. They now say that you are still in attachment after confirming me in service in 2007, madam. They have not taken into account this order in the impugn order. Had they taken into account of this order, my lord, they would not have passed this order. And they have not given me any opportunity whether they have carried out any inquiry. I would have given this order before them, my lord. So this is
Where is that order?
uh,
2007 order?
yes, page 27, my lord. The service of the following LP school teachers of block elementary education officer
Page number
Tengashat.
20.
Page 20, I'm sorry, 26, my lord. I'm sorry. I'm reading this order, my lord. The service of the following LP school teachers block elementary education officer Tengashat are hereby confirmed against their substantive post with effect from the date of issue of this order as this rendering continuous satisfactory service without any adverse remarks since their joining. I am at serial number 6, my lord, number 2 Gulimpura. And in the impugn order, this order is not reflected, my lord.
Okay.
My lord.
Mr. Sarma?
Lordship. Lordship, this page number 24. Here that attachment order has been passed by Deputy Inspector of Fiscal Tribunal.
Hmm.
Page number 24. This attachment order, whereby the petitioner has been attached with number 2 Gulimala LP School. This order has been passed by the Deputy Inspector of Fiscal Tribunal.
Allowed
Now,
to,
this is the order impugned by the petitioner lordship, page number 47,
Hmm.
which it says lordship, paragraph 2. Paragraph 1 from whereas as per report received from the district elementary education officer was appointed as assistant teacher at Gazali Basti AP school under PO Tengaka, Dibrugarh, DIS Dibrugarh, by memo number so and so, and after rendering her service, she was attached with number 2 Gulimara LP school under the same block by PO Tengaka, order number 29/5/2003. Whereas as per WT message of government issued on 25/5/2017, district elementary education officer, district deputy inspector of schools, block elementary education officers were not allowed to transfer or attach teachers as per government guidelines. Also letter white number so and so dated 6/20 January 2026, 2025. Immediate cancellation of all attachment orders given by any authority of the
Mr.
department
Sarma,
was
this is
issued.
my case.
that is after 25/5/2017.
Lordship.
But attachment order was made long back.
Long.
That is
March.
clear, Lordship.
Then-
And even the confirmation
Then
of the.
what is the purpose of issuing this order?
My lord, yes, para 16 I have stated. Just to accommodate my junior, my lord. She is after me that she should get the headmastership. Page 16, para 16, my lord. One Orsona Fukan, my lord.
Let office go and this is
Lordship.
part. Mr. D.K. Das, learned counsel for the petitioner. Mr. D.N. Sharma, learned standing counsel for the respondent in elementary education.
All the respondents, Lord.
Petition, per Article 226 of the Constitution. Yeah, the challenge order dated
29, lord,
29
2020.
28/9/2025 issued under memo number E-701090-78 by the Director Elementary Education Assam. It is to be noted here that by the order dated so the Director Elementary Education Assam attachment of the petitioner is cancelled and she is directed to join in her original place of posting, that is Gazal Basti LP School. as per DIS Dibugor order memo number, order under memo number 10854-60 dated 13/10/1991. Mr. Thus, learned counsel for the petitioner submits that the petitioner was appointed on 13/10/1991 as assistant teacher
of Gozal Bosti LP School, my lord.
of Gozal Basti LP School.
Yes. And thereafter, my lord,
Then, the second line of the appointment order, that is Gokul LP School, what is it?
my lord, page 24, my lord.
22.
My lord, that teacher, he, my lord, retired. My lord, these are on vacancy, my lord, while, my lord, these attachments are there. Then, my lord, post where he was attached, the earlier headmaster, my lord, then the post of Gozal Bosti was vacant and she was appointed. And this, that is wrong, I suppose, in the translation. Assamese is very clear, my lord. Bokul Prathomik Bidyalaya Sri Subhas Dakhor, Pradhan Shikhok, Obohor Hoat, Gozal Bosti Prathomik Bidyalaya Nirbachito, Srimati Mamta Ghoshor, Probeshika Snatok Oti Osthayi bhabe niyukti dia hoy. My lord, from in Gozal Bosti.
Gozal Basti LP School.
Yes.
By order dated 13/10/1991.
Just
There's
page 24.
On the very next day, the petitioner was attached.
Allowed to join, my lord. Attached word is not there.
Petitioner was allowed to join in number 2, Gulipara LP School. As there was no assistant teacher in the said school. Thereafter, the petitioner continued to render service in the said school, and her service was confirmed by order dated 26 August 2007. 2007. And after retirement of the headmaster of the said school, she was allowed to take charge of the in-charge headmaster.
Yes.
In-charge headmaster.
Page 27, my lord.
By order dated 29/5/2018. And since then, she has been working as in-charge headmaster. Thereafter, suddenly, the director, elementary education, has issued the impugned order dated 28/9/2025, whereby her attachment to
Gozal Bosti.
to attachment with number 2 Gulipara LP School was cancelled, and she was directed to join in her original place of posting, that is Gozal Basti LP School. Sir thus further submits that while passing the impugned order, the director has failed to take into account the confirmation order dated 26 August 2007. That in view of the Section 4,
Rule 4, my lord.
Rule 4,
Of Assam Elementary
the Assam
Education.
Elementary Education Provincialization Service and Conduct of
Madam.
1981. After confirmation of the service,
Attachment cannot conflict.
no adjustment can be made. And besides, Mr. Das has pointed out that in the impugned order dated 28/9/2025, the director has referred to a WT message issued on 25/5/2017, wherein it is stated that attachment of the officers, no, attachment of the t-shirts as per government guideline are not allowed. Not allowed. But Mr. Das submits that long before issuance of the said WP message on 25/5/2017, the petitioner was attached with the Gulimara LP School, number 2 Gulimara is LP School. Gulimara LP School by order dated 14/10/1991. And referring to paragraph number 16 of the petition, Mr. Das submits that the impugned order was passed only to accommodate one person of Pupan. Have you implemented her as party in this process?
My lord, since in the impugned order, there is no mention whom to given the search, I have not made the party. This is my suggestion, my grounds. my lord.
And under such circumstances, Mr. Das submits that the impugned order is arbitrary and illegal and liable to be interfered. Yes, Mr. Sorma, what is your submission?
My submission is that assessment order was passed by the Deputy Inspector of the Court process. And in terms of that memorandum of the government law six notification, where that WT message also, if you can 17 district elementary education officer, TIR schools, block elementary education officers were not allowed to effect any transfer or attachment orders. It is specified in the, and moreover, lordship, one more, may I take a lordship to this page number 24. Here, although the petitioner was attached with that, number 2 school, but she was allowed to draw her salary from the original school. Lordship, may kindly come to page number 22.
Prior to
24. In the interest of so and so, is hereby allowed to join so and so in the till revocation of this order, you are allowed to receive salary in the school wherein you were appointed. Meaning thereby that he is drawing salary from the original school where he was appointed.
Yes,
My lord, this is for a particular period. My lord, after this attachment, my lord, page 26, confirmation order, my service has been confirmed in the present school. I am receiving salary here. This is my substantive post now, my lord. After confirming me in the service as per rule 4, my lord. Page 26, I am receiving salary regularly here, my lord. And this is a mention.
okay.
This was earlier arrangement.
Par contra, Mr. P. N. Sharma, learned standing counsel for the respondent in elementary department as a both. Mr. Sharma has pointed out to the order.
Lord.
Dated 14/10, attachment order dated 14/10/1991 and submits that though the petitioner was allowed to join number 2 Bukimura LP School, it was directed that she will receive her salary from the said school till revocation of the order. And under such circumstances, Mr. Sharma submits that the order suffers from illegal impropriety requiring an interference of his part. But in reply, Mr. Das submits that after confirmation of his service in the year 2007, the petitioner was confirmed in a substantive post in the present school, where she has been working in the year 2007. And since then, she has been drawing her salaries from the said school. Be it as it may, at this instance, notice be issued to the respondent, returnable in 4 weeks, they be taken by registered for ATM also by the process. No formal notice is required to be issued since Mr. Sharma entered appearance and received notice on behalf of all the respondents. However, extra requires a copy of the petition be furnished to him during the course of the appeal. Further, taking note of the submission of card and copy to both the parties. Also, considering the facts and circumstances that occurred, the prima facie case appears to be made out in favor of the petitioner, and accordingly, the balance of convenience and the irreparable loss is also found in our favor, and accordingly, the order dated 28/9/2025 was by the Director Elementary Education. Kaile Paraguati stands state still returnable that list of the forums.
Deeply obliged.
Item 30.
Hello. Regarding compulsion of your lordship, away, madam, kindly have a look at page 27, madam. Kindly agree on this, madam. Page 27, madam. I was asked to appear, madam, before a concerned authority with relevant documents, madam, for compulsion of it. After that, madam, no, there is no communication between, madam. Page 27. My name is at CL number 31. But I submitted all my relevant documents, madam. Even then, madam, they have not communicated, madam, whether my candidacy has been rejected or not. That much, madam, I am paying, madam.
Thereafter, what happened?
No, nothing. No, madam, no, there is no communication.
So what is your pair now?
But if my lord rejected, my lord, then my lord, I have no case, madam. If not rejected, my lord, I have to know, my lord. If my lord not rejected, not considered, then my lord, then my lord, next GST, my lord, my name is considered. Madam. This is the only contest.
So, person to this letter, you have appeared before the.
Madam, I have appeared, I have
Yes,
submitted all
yes,
the
yes.
documents, madam.
Thereafter, what happened?
Thereafter, my lord, there is no communication, madam. They have not informed me, my lord, whether my candidacy has been rejected or my lord allowed, my lord, nothing.
Yes, madam, you are appearing here.
Your lordship, in the prayer portion in number D, your lordship, where here, what he is writing, your lordship, a read in the nature of
Hmm.
mandamus should not be issued, directing the respondent authorities to allow the petitioner to submit the record, whether he has.
That is, madam, that is in,
Whether he has submitted his documents or not, then why?
that is regarding, madam, page 28, madam. That is regarding page 28, madam. Where, madam, the deputy secretary, madam, now issue a communication, madam. Issue a notice, madam. That is regarding, madam, page 28.
Page 28, this notification, he is not covered, your lordship, he has filed his case after the month of March, your lordship, 3/4/25, after 3/4/25.
Well, again, well, according to notification, well, again, well, required documents are asked to submit, madam. And after, my lord, I have, madam, submitted, madam.
He can go to the department directly for asking those documents are accepted or not, your lordship.
Madam, it is the duty of the authority, my lord, whether my candidacy has been rejected or my lord allowed. Madam. They have to inform me, madam. Because my lord, 21/9/24, my lord, specifically, my lord, asked me to, my lord, submit a required document. This is my right, madam.
Madam, can you obtain impact on what happened thereafter?
Madam.
This annexure after this issuance of annexure F, sorry, E. Dated 21/9/2024. Art means a conical, learned. Advocate, learned advocate. For all the respondents,
Respondent number 2 and 4, your lord.
four, that's the day for four, that's for 1 and 5. The petitioner is aggrieved for unconsideration of his candidature for being appointed for being appointed on compassionate ground. Compassionate ground. Mr. Conifer learned counsel for the petitioner submits that the father of the petitioner was serving in where he was serving.
Father of the petitioner.
Yeah.
The headmaster, my lord, Nimsi Nimai Sanpur Emis Madrasa.
Father of the petitioner named late Abdul Hakim Laskor suffered demise while he was serving as headmaster in Nimai Sanpur Emis Madrasa on 1/6/2007. After the demise of our father, the petitioner has applied for being appointed on compassionate ground on 27/2007. But the same was not considered by the respondent of this for which the petitioner approached this court by filing a writ petition being writ petition number. Where is that writ petition?
It is on page 17.
Page 7, writ petition. Being WPC number 758 of 2023. However, the date writ petition came to be dismissed by the order dated 15/12/2023. And thereafter, the respondent authorities had issued one notice on 21/9/2024. 21/9/2024, wherein at serial number 31, the name of the petitioner was mentioned. And in the said notice, the petitioner was requested to appear before Srimati Pooja Dolagabo, SAS, Assistant Commissioner Hailakandi, and Executive Magistrate, and Srimati Janadi Langkasa, ACS, Assistant Commissioner Hailakandi, and Executive Magistrate on 23/9/2024 from 11 AM in the office chamber of the District Commissioner Hailakandi. But on the end, the petitioner had appeared before the said executive magistrate on 23/9/2024. But since then, she has not been receiving any communication from the respondent authorities. Under such circumstances, it is provided that Ms. learned standing counsel, learned government advocate appearing for the respondent numbers to obtain up-to-date status of the aforementioned process and to advise this court on next step. Release the matter on
31st of
Deep Lord.
timing item 28 for motion.
Please, your lord. This case, Your Lordship, the petitioner, Your Lordship, has participated in a selection process, Your Lordship, initiated by the advertisement number dated 13 February, that is at page 104, Your Lordship, by the Borderland Territorial Council, Your Lord. Altogether, Your Lordship will find, Your Lordship, applications are invited from eligible Indian citizens as defined in Provincial Constitution of India and permanent residents of Assam for filling up 1472 vacant posts of graduate teacher arts, graduate teacher science, graduate teacher Hindi. We are concerned with this, Your Lordship, graduate teacher Hindi in Assamese medium school, Your Lord. No?
Lordship, in similar matter, Lordship has already issued notice of it. In this case also, Lordship, so far as the non-BTO part is concerned, select list has already been prepared. Now it has been forwarded to the PTP authority for approval. But in the meantime, Lordship, MCC came into effect, so nothing, it's not called there. So MCC is going to be, put on- it will remain effective tomorrow or day after tomorrow, Lordship. So Lordship will take up this matter after vacation, Lordship. In the meantime, what can let's see. Lord, only the approval part is.
That observation may be recorded.
Art, Mr. As part of our Lord, I call for the, sorry, okay, I have heard that stuff, of it. In this petition under Article 26 of the Constitution of India, the petitioner tried to direct to the respondent or to publish the finished list of non-BTO candidates for the post of graduate teacher certificate person to the advertisement dated 30/2024 by the Director of Education, PTC Kuprajar, and also to appoint the petitioners to the post of graduate teacher in the Department Provincialization Secondary School of Voluntary to the region. Mr. P. Nayo, learned counsel for the
All the rest.
summons that in connection with similar methods, this court has authorized it to notice to the respondent. Then he also advised it for that the list has already been prepared and the same has been sent to the PTC for approval.
Yeah.
PTC for approval.
Okay, that is telephonic instruction, Lordship, cannot like
As
this
part
for-
of telephonic inspection, the list has already been prepared and sent to the PTC authority for approval. And once the approval is received, the list will be published. Under such circumstances, Mr. Nayak submits that the matter may be listed immediately after the opening of the according taking note of the submission of part of both the parties provided that to issue notice at
Lord,
notice. Provided that notice is to the respondent returnable 4 weeks. However, no formal notice is required to be put the respondent authorities and all of them are present by the start. Nayak, correct. Nothing concept. However, extra set copy of the part. This the matter after the text or dioxide of the applicants enterprise is for the next return. This the 4 weeks.
Lordship may fix a date, Your Lord.
After 4 weeks. On 10th November.
Deputy Obliged.
Item number 5 for implement of part. Number 5.
That appears for the applicant on call. How about Mr. C. Borua, learned
For
Standard
three, my lord.
Counsel for
Three.
AG, respondent number
AG.
3. And
Still, it is
Mr.
petition
Gogol
as
for
for impleadment as per last order. Yes,
Mr.
file
Gogol
also,
for
but he is
respondent
not
number
there.
4. Number 1.
Okay.
Respondent number 2. Present.
I have not received a copy of the
Applicant is approved.
The movement will be.
List the matter immediately after the event. In the event of subsequent non-representation of the applicant, I put that order to public.
Obliged.
Item number 6,
Equal three.
Implicit petition, my lord, praying for respondent number 4, 5, and 6, my lord. Earlier incumbent, my lord, 1, 2, 3 already retired, my lord, SS, my lord, 4, 5, 6.
Heard. Mr. A.M. Ahmed, learned counsel for the applicant. This interlocutory application is prepared by the applicant for implement of 1. Adil Khan, Secretary to the Government of Assam Irrigation Department, Dispur. 3. Propository Roy Sotori, Secretary Irrigation, Satmari, Guwahati. And 3. Manoj Deka, Executive Engineer, Timuria Division, within bracket Irrigation, Sonapur. Yes, respondent number 4. Respondent contender number 4, 5, and 6. Mr. Ahmed submits that the earlier incumbent named Provincial Raj Howe and Fazal Nohat Siddiq and Sri Ratul Kusami. What happened to them?
My lord,
What happened to them earlier?
earlier they are retired. Retired.
Already retired from service prior to- and in their place, the new government had taken charge of the office, and as such, they are required to be implemented as respondent number 4, 5, and 6 in the respondent case number 566 of the accordingly, taking note of the submission of Sir Ahmed, learned counsel for the petitioner, the counsel for the applicant, and also consider the circumstances on the record. This interlocutory application stands allowed. 3. Adil Khan, Secretary, Dr. Assam Irrigation Department, and 3. Propository Roy Sotur, Secretary, Irrigation, Satmari, Guwahati, and 3. Manoj Deka, Executive Engineer, Timuria Division, Certificate Irrigation, Sonapur, shall be included as respondent number 4, 5, and 6. In terms of above this, IA stands disposed of. In view of the order passing the IA, the Ahmed learned counsel for the petitioner, the counsel for the applicant shall file amended was titled in the contempt case number 566 of 2025 in a period of 1 week from today.
items for admission.
Re-add, my lord, thereafter I may be allowed to take steps.
If file amended was titled in the main contempt petition, will pass the order.
Obliged.
Items for admission, item number 7,
Well, here in this case, actually certain amount is due to the petitioner, my lord. I'm your lordship will see this,
Laptop into video is
my lord, 4,17,900 is accumulated against her pension, my lord. So, my lord, another letter has been issued by the department. They, if I abandon this amount, surrender this amount, then they will pay me the regular pension calculating, but this amount is to be surrendered. So my humble submission before your lordship, I am a lady of 97 years old. So my lord, monthly pension will not do. If that amount is paid to me, my lord, I will be satisfied. That 4,17,000 amount accumulated. It's up to the learned friends, my lord, what they say. Within certain time, my lord, this amount they have calculated, my lord. If it is paid, I will satisfy. Because I am as a person, my lord, I will not survive for this regularization, etc. For regular pension.
We have filed our affidavit.
My lord, in the affidavit, there is nothing.
Page 33 onwards, your lordship. Paragraph.
My lord,
7.
in the affidavit, it is only said that for the wife, my lord, 3 lakh was sanctioned. And that 3 lakh was given to the wife. That wife now entered into second marriage, so she is not entitled to pension. That is the affidavit. The affidavit, my lord, it is filed on.
Your lordship, in paragraph 9, page 34, it is also mentioned that under the scheme, your lordship, that is covered under the new pension scheme, as per the rule, scheme respondent number 6, that is Rekha Bora, is not eligible for family pension also. From the date of her remarriage, rather it is to be paid to the eligible next of kin. In fact, so far, no family pension or pensionary benefit except 3 lakhs only as GIS insurance money has been paid to Rekha Bora.
Come on, that is my submission, my lord. Rekha Bora is not entitled. Mother is entitled, and already, my lord, mother has been paid 1 lakh rupees, and this monthly pension of 10,000 and plus. So, my lord, now it is accumulated that 4,17,000. That is dear letter, my lord. It is the Director of Accounts and Treasuries.
Just in the morning,
22
Yes.
matters.
he has mentioned the matter, praying for adjournment. So, you were appearing for respondent number 6.
Headmaster connected. Party connection. After logical. And your lordship, 7, respondent number 7 is also necessary party, your lordship, because in our affidavit also, page 35, it was clearly mentioned that the reply from the headmaster is awaited, and only on receipt of relevant records regarding next of kin,
Those the service has been done, my lord.
the deponent would be able to
Service
forward
is
the
complete, my lord.
pension
Service is complete. That is why, my lord, your
pension
lordship,
proposal in
Ac-
accordance with the relevant provisions.
it
your
is
lordship.
listed for admission.
Next of kin records would be necessary, and your lordship, the headmaster is a necessary party here.
Headmaster was impleted.
Impleted, your lordship.
Impleted, and those the service was done on him, my lord. Service is complete. my
Not
lord.
appeared then. What to do?
Those the service filed on 22/8, my lord, 2020.
Mr. Sheikh, the council for the respondent number 6, right for adjournment of the matter.
My lord.
Respondent number 6, in the morning hours, prayed for adjournment of the case.
Today,
Today,
yes, my lord. Respondent number 6.
6.
Respondent
So
number six.
Mr. Biswas is the council for respondent number 6. He is absent today.
We'll file our affidavit.
Rekha Bora.
When?
We'll file our affidavit in this matter by, on just immediately after the vacation is over, on Monday, Monday or Tuesday, October.
My lord, my humble submission before your lordship. if your lordship go by this document I have forwarded, if they settle this matter as they calculated, my lord, we will be satisfied. Because, my lord, if the matter is delayed, my lord, I will be nowhere. My lord, I am 97 years old. I am counting my days.
No, that's all right, but without hearing all the parties, can we
My
pass
lord.
the order?
My lord, document is there, my lord. It is not my document.
Document
is
is
there.
there, but we have to hear all the parties.
My lord.
Today, Mr. Biswas is absent.
My lord. Yes, my lord, regarding Mr. Vishwas, my lord, that can be considered. Because Mr. Vishwas prayed already adjournment. my lord.
Yeah.
If that is so.
He's not absent today.
So immediately after reopening,
My
in
lord.
the meantime,
But my humble submission before your lordship, my lord, what my learned friend is submitting, that may be last chance to them. Because, my lord, they will take time one after another and she will die.
Your lordship, headmaster party is necessary, your lordship, in this matter, your lordship, because he will be the provided, your lordship, relevant documents. In our affidavit also, we have.
Headmaster
written
is a party here.
that. That is not our fault, your lordship, he is.
Oh, headmaster is a party respondent. We have served notice. You have not gone through the record. Performer respondent.
But today he is not appearing, your lordship.
Oh, he is not appearing. Dosti service has been completed. Not going through the record, something has been completed.
okay, heard Mr. MSA, learned counsel for the petition.
Last occasion, service is complete. That is why it is in admission.
Number 1 and 4. That means, your name, please.
No.
You know the learned counsel appearing on behalf of Mr. Biswas has been the learned contacting counsel for the document number 6. And anybody for AG? The A does learned counsel appearing on behalf of Mr. Biswas, learned contacting counsel for the document number 5. And Madam Kupar for document number 2.
I am appearing for 1 and 4.
Ms. Nanda learned counsel appearing on behalf of Mr. S.P. Biswas. S.A. Biswas, learned conducting counsel for the respondent number 6. Submits that Mr. Biswas is out of station. And she
No,
transfer.
I don't want to pray for that. I just want to pray that, we'll file our affidavit.
Okay, okay. Submits that she may be granted some time to file affidavit in opposition. There is accordingly allowed, lesson supplies the matter immediately after reopening of the petition. And in the meantime, Ms. Nanda, learned counsel for the respondent number 6, shall file her affidavit in opposition. Please the matter.
My lord, it may be the last chance, my lord. Otherwise, I will lost
20
my
seconds
chance.
Keep your play.
on 22nd October.
When as a last chance, my lord.
Second last.
Hello. Oblige, your lordship.
Item number 10,
So the affidavit has
My
been
lord.
filed.
My lord, we have not filed the affidavit, my lord. We have received the instruction that the appointment of the petitioner is, my lord, was illegal, my lord. Finance department stopped the salary as the petitioner was appointed, my lord, against the personal post, my lord. So, my lord, salary, finance department did not, could not release the salary. So we not file the affidavit, lordship, and grant some time, fix it on, my lord, 27th October. We will file the affidavit. Against the personal post, my lord, petitioner could not be appointed without basis, without any selection. Umadevi case is clear, my lord, in this regard, my lord, that if the appointment is illegal, my lord, then, my lord, he cannot be allowed any benefit. my lord.
Appointment 2008, they are saying after long service.
Appointment order itself says that he was, petitioner was appointed against the personal post. Personal against the personal post is abolished as and when the
No.
person is retired from service. my lord.
When the
Against that post,
you
without
internet
any
come in-
selection, he cannot be appointed. We have
Okay.
not filed the affidavit, lordship, grant some time. my lord.
That the affidavit.
That's fine, but
Heard-
they are taking
heard
time,
Mr.
several days.
Yasmin,
On 2 days, not 7 days.
learned
Three
counsel
days
for
they
the
are taking.
petitioner. And Mr. Devapriya, learned
No,
counsel
3 days.
for the
Both ways, they are not
number
this way.
6 to 9.
22 days, it says.
Sir? Case number fourteen. Junior government advocate for respondent number two and May 45. Five and Mr. Case only have for respondent number two and Madam for respondent number six.
And for 629.
Okay, Mr. Sophia Lordet is the next counsel for the respondent number 629 submits that it may be granted some time to file the affidavit in Pututi. And price for listing the matter on 27th October, where is according to allowed, the list the matter of 27th October.
Item numbers 11 to 15.
No, primary local instruction.
Please, Your Honor, password for time being.
No, your lordship, in this matter, your lordship, up-to-date instruction
My-
is still awaited, your lordship. So
My
we
senior
will
is lagging on 21.
Posted this matter after vacation. Your lordship, there is a categorically stated that each and every candidate detailed report is needed, your lordship. So your lordship, in this matter, your lordship instruction is awaited. So kindly I pray for your lordship short time, your lordship after vacation.
No, madam, you see on the other day, Mr. Sharma appeared. You Sharma.
Your lordship,
Then
he
he was
requests
ready
your
to
lordship,
obtain instruction.
as instruction is awaited, your lordship.
Your
So you-
Honor, please, password for time being. My sir is lagging on
Okay,
21.
let his senior come.
Okay.
Item 16. Non-payment of salary, my lord, of 2 months. On the last occasion, counsel for the PHC, my lord, was supposed to bring instruction. My lordship may kindly see page 15 that I already sought done. And salary for the period of February 2016 and February 2018. 2 months salary. Not
D.
paid.
Gogoi is present. Is present in the court.
PhD will be there, sir. That's it.
Okay.
I'll just inform the sir.
Okay.
Well. Item 17.
May I please, your lordship, on last occasion, your lordship directed to furnish instruction regarding whether the suspension order of the petitioner was reviewed or not.
Mr. Nayak.
Mr. Nayak was supposed to appear now.
Okay. Wait for some time.
Lordship. All right.
For bail hearing, item 19. Item 19.
May I please, Your Honor? Your Honor, we have filed affidavit day after yesterday, Your Honor. It was not tracked with the record, Your Honor. So kindly matter may be taken up after 2
After?
2 p.m. Your Honor.
Lord, may I please your lordship? Your Honor, it won't be possible for Mr. FCR to appear after 2 years. Matters already fixed at 2 years.
Where?
Your lordship, in court number 16, your lordship, and there's a, in court number 6 also, your lordship, delivery of order is also set.
So after vacation then,
Yes, sir.
hard mess,
N Khatun, Your Honor.
learn it for the active and also hard mess,
You can't hear.
learn it counsel appearing on behalf of the client, learn it counsel for the exhibit, standing counsel for the exhibit. The learned counsel for the active submits that he has filed additional affidavit and the same is not placed on record. And so learned counsel appearing on behalf of the client submits that the client take from a record. And according, it is provided that residential is the matter immediately after the event. enclosing the affidavit, additional affidavit filed by the accused along with the report.
Date may be fixed, Your Honor. 24th of like.
For orders, item 20.
Upload of the post.
Peter. No, it's data. Report. Data.
You lost its order, my lord.
Yes, I say.
You lost its order, my lord, 8/9/2025. There is an observation, my lord. Thereafter, they took another plan.
But the council is absent today.
Oh.
They would put the council. Wait, something.
21.
May I please, Lordship? Lordship, this interlocutory application has been filed for exposition of writ petition number 3170/25, which was dismissed for non-prosecution, my lord. But the fact is that, my lord, the engaged advocate was died in 2019, my lord. COVID pandemic, my lord. The engaged original advocate was died. That's why he could not contact, the client could not contact with him, my lord. That's why the case was dismissed for non-prosecution, which may be, my lord, restored, my lord. And restoration petition has been pending for 2 years, my lord.
Yes, Mr. Henrik. Mr. Henrik. You were referring for respondent number 123.
Lordship.
So you have been asked to file a affidavit in opposition. Where is your affidavit?
Oh, okay.
My lord, origin matter was relating to appointment of a Gabura, my lord.
Appointment of
Gabura post, my lord. Gambura, my lord. And which was dismissed for non-prosecution, my lord. Advocate
Then where is the medical certificate?
medical certificate,
The medical certificate means that death certificate.
death certificate, my lord. You have not his death certificate, my lord. Advocate A. Sharif, he died during this COVID pandemic, my lord.
No, unless your contention is supported by any
My lord, the
death
client
certificate, can we accept your contention?
client could not arrange the death certificate, my lord.
Pardon?
The petitioner could not arrange the death certificate from him, my lord, from his family, my lord. It is a genuine fact, my lord. He has died, my lord. Advocate A. Sharif, the engaged counsel, previous engaged counsel, my lord. It is a fact, my lord.
My lord, initially, my lord, it was, my lord, that the Kavura post was, my lord, that qualification is, my lord, that not required, my lord, that I can, exigency pass. Now, my lord, it is mandatory, it is required.
It is in the main petition, my lord, main writ petition. Now this is the IA, my lord, for restoration, my lord. We'll go through, my lord. Matter may be restored, my lord. And restoration pending matter has been pending for 2 years, my lord. I decide. After it restoration, we can go for merit or demerit, my lord.
So you have filed your affidavit in opposition. No, respondent number 5, or no, 4. It's the private respondent.
Private respondent. Private respondent.
That notice have to go to the private respondent also.
Service completed, my lord. He has filed his affidavit also, my lord.
No, my lord, that in respect to my lord, that I have filed by the Malana.
No, in IA, this affidavit has been filed.
It was for restoration petition.
I'll if you.
It may be restored, my lord. Merit and demerit may be considered after the main writ petition, my lord.
So this I is for
Restoration.
condonation of delay.
Delay.
Whether any other I is pending.
Yes, my lord. There is one another, my lord. Miss case 70 of 23.
Away.
Together, my lord.
Yes.
Miss case 70 of 2023. That is
First, we have to condone this delay only thereafter the restoration.
Lord.
my lord.
So Mr. Hendrik, you have no objection in
No, Lord.
condonation of this delay.
My lord, problem is that in the next week, my lord, the DC has arranged a hearing on that regard, my lord. That's why.
Third, Mr.
MH Soikia, my lord. MH Soikia.
Learned counsel for the applicant. This application under section 5 of the Petition Act. 3. Is preferred by the applicant for convocation of debate of 1,443 days in filing the restoration application for restoration of WPC number 317 of 2015, which was dismissed for default by order dated 31/8/2017. The learned counsel for the applicant commits that while the writ petition was listed, writ petition number 3172 of 2015 was listed before this court on 31/8/2017. The conducting counsel could not enter rebellion as he has suffered demise in COVID-19. So in 2017, COVID was not started. 19 people.
My lord, 19th was he died, but he has been bedridden for several years, my
He
lord.
was dismissed on 31/8/2017.
My lord.
Last before this.
My lord,
COVID-19.
the petitioner has lost the contact with the advocate, my lord. He's as an advocate, my lord. He has been bedridden for several years, my lord. That's why. He was bedridden for several years, my lord.
Who?
Mr. A. Sharif. late Mr. A. Sorry, my lord, the
The
Angus
convicting
counsel,
counsel.
Angus counsel of this case, my lord.
But you have no medical document.
We have no medical document, my lord, but the petitioner lost contact with him, my lord.
Where is your averment in your applications?
Yes. My lord, para 3 of the delay conduct petition, my lord. IA 2701. Page 3, my lord, para 3.
Okay.
3 and 5, my lord, para. In the restoration petition also, my lord. It was the 3 and 5.
It was right.
It is what I mean.
Conducting counsel remained absent for which the petition came to be dismissed. The learned counsel for the applicant further submits that the applicant did not conflict with his conducting counsel, Mr. A. Sorry, who was bedridden for how many years?
My lord,
Bedridden for how many years?
I don't have the idea, my lord, but I heard that he had been bedridden for several years, my lord.
Several years. Several years for which the petitioner could not conflict with him, and ultimately on 14/8/2023, while he came to the High Court to inquire about his counsel, Mr. A. then he came to know that A. suffered demise in COVID-19 pandemic period. And therefore, the applicant has engaged another counsel and came to know that the writ petition filed by him came to be dismissed by order dated 31/8/2007. The learned counsel for the applicant further submits that the delay in filing the condemnation petition is not intentional, rather it is circumstantial. And under such circumstances, it submits that the delay may be condoned and delay in deferring the restoration application for restoration of WPC number 3172 of 2015 may be condoned. Mr. Hendrik, learned counsel for the respondent numbers submits that he has no objection in the event of condoning the aforementioned period of delay. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the statement that Department made in the application, especially in paragraph number 3 and 5, this court is of the view that the delay has sufficiently been explained and accordingly the same is met. Art Mr. Sunito, learned counsel for the petitioner, petition. This case number 7. Then also Art Mr. Hendrik, learned
For respondent number 1, Lord.
respondent number 1. And Ms. Porwa for respondent number 20. Here we have to issue notice to the private respondent number 4.
My lord, already notice has been issued, my lord, and they have submitted their affidavit, my lord.
In the Okay.
Both the matter are take together, my lord.
Hold this. None appears for the respondent number 4. Okay, written right. Report. J. J.
My lord, it is Joinal Abdin Ahmed.
Have you seen it today?
No, my lord.
Their name is shown in the list.
Shown in the list, my lord.
None appears for the respondent number 4. This case is referred for restoration of the rate petition number 3172/2015-5, which was dismissed for default on 31/8/2007. The learned counsel for the petitioner submits that earlier, one Mr. A. Storif was engaged by the petitioner, and the petitioner lost contract with him, and as the petitioner could not contract him for a long period, the petitioner came to the High Court to inquire about the status of the rate petition filed by him. And then on inquiry, he came to know that Mr. Storif suffered demise during the COVID-19 pandemic season. And thereafter, he engaged another advocate and obtained the copy of the rate petition, of the order of the rate petition number 31, and the rate petition dated 31/8/2017, and came to know that the same has been dismissed for default. The learned counsel for the petitioner also submits that as the petitioner could not contract with his counsel, and as the conducting counsel suffered demise in the COVID-19 pandemic, the non-representation of the petitioner on 31/8/2017, on which the rate petition came to be dismissed, was not intention, rather it is circumstantial and circumstantial to restore the WBC number 3172/2015 to date. So I think that Ms. Borwa submits that they have no objection in the event of restoring the WBC number 3172/2015-5. So the respondent number 4 filed a affidavit in opposition. Here, none appears for the respondent number 4 today. Accordingly, taking note of the submission of Sir Sucho learned counsel for the petitioner and also Sir Henrik learned standing counsel for the respondent number 1 and Ms. Borwa for respondent number 2. This court is inclined to allow this petition. Accordingly, the WPC number
3172. 3172.
3172 of 2015 shall be restored to 5. This is the list of methods immediately after the opening of the petition.
Obliged, my lord.
My lord, the date may be fixed, my lord.
Take it that.
Obliged.
May I please, your lordship?
Yes.
Lordship, this is a review petition directed against an order passed by your lordship, which your lordship will find at page 127. And primarily, lordship, it is on in the context of order 21, rule 97, 99, and 101. Lordship, on the basis of our judgment rendered by the Honorable Supreme Court in Brahmadev Chaudhary versus Rishikesh Prasad Jaiswal, your lordship will find that at page 130. based on this judgment, Lordship had formed the view that the respondent, that a petition filed by the respondent before the court below under Order 21, Rule 97, 99 and 101 was okay, and your Lordship had rejected the revision petition. Now, if I may just take your Lordship to the provisions of the CPC for a moment, Lordship.
Mr. Sorore, this is a let notice go.
Yes, because well, considering-
We'll hear you, let the other
Yes.
side come.
Yes, but Lordship, I am praying for a stay of the order passed by your Lordship and the proceedings in the court below, because that will prejudice me if it continues till the returnable date. If they appear, Lordship, it is hardly a matter of a day for your Lordship to decide.
So you take a step.
I'll take
Next
steps
day
today
we'll
itself.
see, let the other side appear.
Only till the next date, Lordship, I am praying for some interim relief. If the case proceeds, Lordship, in the court below, I'll be prejudiced, Lordship.
And what it says the case is pending.
Lordship, the respondent is to file their evidence, Lordship. Lordship will fix a short date, Lordship, and the order of
Yes,
the
in that case, that lady was not.
she was
impeded
not
as party.
impeded as a defendant, Lordship.
Yeah.
Now, what had happened? We were not in the knowledge that she was a member of the opposite
Family.
party, of a family, Lordship. Now, she had filed a petition after the decree was passed in favor of me, and I went for execution. She appeared. Then she had filed a petition under Order 1, Rule 10(2). That was rejected. She filed a misappeal. That was rejected. Now she has filed a petition under Order 21. Now, Order 21 petition can be filed only by a decree holder. She is not the decree holder. I am the decree holder.
No, even third party can also.
No,
file.
that is why Lordship had relied upon a decision of the Honorable Supreme Court, which was clarified later on. But perhaps that was not placed before your Lordship. And on that ground only, Lordship, review lies.
Okay, let the other side appear. We consider your interim
Lordship.
on that. Today, let notice.
Till that date, Lordship.
No. Because in spite of being family member, she was not impeded as party.
No, she has, when she had filed an application on the Order 1, Rule 10(2), she has to satisfy the court. She could not satisfy the court. She has simply made a statement. She could not deduce anything credible. That is why the misappeal was also rejected, Lordship. She had two chances.
Okay, heard Mr. R.K. Sotomayor, heard counsel for the applicant. This application under section 114 of the Code of Civil Procedure, with order partition to one of the Code of Civil Procedure, is preferred by the applicant for review of the order dated 6/8/2025, passed by the owner, passed by this court in Seniority IL number 108 of 2025. Whereas the application and the documents to record and also whereas the order of this court dated 6/8/2025. Let notice be issued to the respondent for returnable in storage. Or you can start notice by the same.
Lordship may keep both the options, Lordship. I will. The stay will be easier, but there is a vacation in between, Lordship.
Yeah.
So that is one thing, Lordship.
Returnable in 2 weeks. Step be taken by registered post with AD and also by usual process. within a week from today. Additionally, justice service is also permitted. Place the matter after 2 weeks immediately after reopening of the vacation. Entire fare of the petitioner will be applicant will be considered on next returnable day. But where is the decision you have relied upon?
I have it with me, Lordship.
Okay.
I have it with me because, in fact, there is a review preferred by me in another court in a similar matter, where a decision of the Supreme Court was holding the field, and somehow or other I failed to place it before the Honorable Court. The Honorable Court did not have the occasion to go through it, and that is said by the Supreme Court to be a error apparent on the face of the record and a ground for review itself. And I will be relying upon that, Lordship. The Supreme Court decision is of a later
You
year.
have the soft copy or hard copy?
I've got a hard copy. I can give you, Lordship. I'll take it out.
Please furnish the record.
Yes, yes, yes.
Item 24.
May it please your Lordship. This IA is filed for restoration of the CRP IO number 16 of 2025. It was my lord on 8/8/2025. My lord, what happened? Your Lordship, my lord, opined that under Order 9 Rule 7, the CRP IO will not lie under Order Article 227, my lord. But after that, my lord, I have gone through and have stated in paragraph 4 of this IA, my lord. Because this suit is pending between the parties.
No,
because
Mr. Goswami, you see,
my lord,
this was a consent order.
yes,
On
consent
that
order.
day, both the council
Yes,
had consented in
Yes.
passing this order by this court.
yes, yes. What happened, my lord? We have found,
Now, where is the question of restoring the CRPIO?
my lord, the fact is this, there is no such provision to go before the trial court or any appellate court below, my lord.
The other day, you have left the court. Thereafter, you came back.
Yes, yes, my
Then
lord.
you
Your
have
lordship,
submitted before this court.
your lordship,
Then
in
we
fact,
passed this consent order. Now you cannot agitate against that order.
my lord, there is no way out because otherwise, my lord. Because on that day, he also, learned council also consented that if he is given 30 days time, he will file WS, my lord. Because it is in between brother and sister, my lord.
Maybe.
Regarding,
Maybe.
it's in between brother and sister, my lord, and only the fact is this, my lord, the expertise order, she resides in my lord, Tezpur.
You have withdrawn the petition. Now, where is the question for restoration?
The fact is this, my lord, otherwise there is no provision. Because
you
your
tell me.
lordship, in one, my lord,
After withdrawal of the petition, is there any provision for restoration of the same? Under which provision you have filed this application today?
my lord, there is nothing, my lord.
Then
No, my lord, it is like dismissed for default, but one liberty was granted.
How
No, my
withdrawal,
lord,
how
what,
withdrawal amounts to dismiss for default? You show me.
my lord, your lordship granted me liberty, but on that day, due to hurry, my lord, both of us, my lord, we talk. And since because, my lord, the suit is pending for long time.
No, this is
My
not
lord,
the way, Mr. Goswami.
what happened? Your lordship passed one judgment that is different, my lord. Your lordship on this point regarding on 6/8/2025, a few days prior to this order, my lord, your lordship passed one order. Your lordship may kindly peruse. In that case, why it was dismissed? Because, my lord, that was decreed. That was decreed, my lord.
No, Mr. Goswami, you tell me, where is the provision for restoration of a case after withdrawal? You come prepared after vacation?
Yes, my lord.
Heard Mr. Goswami, learned counsel for the applicant, and also heard Mr.
M. Pandit.
M.
Pandit. PANDH.
Learned counsel for the respondent opposite party. This application is prepared by the applicant for restoration of CRP IO number 16 of 2025, which was disposed of on withdrawal. In view of the order dated 8/8/2025. List the matter immediately after reopening of the vacation for further consideration on the point of maintainability of this application.
Obliged, my lord.
Timing items. Item number 4 for motion.
May I please, as a lordship?
Yes.
Lord, on the last occasion, my lord, the learned government advocate was asked to obtain an instruction regarding the 1951 notification, by
Yeah.
which the age is being can be relaxed, my lord. Anything? Lord, in
So yeah,
fact,
that notification is available with you.
How it
3/5/1951.
related, but I don't know, my lord. But we have sent a letter on 22nd, but we have not received yet. But how it is related, I don't know, ma'am.
Oh.
Notification 3/5/1951. How
No,
it is?
but his entire case is based on that notification.
Yes, he says the upper limit of the promotion age is arbitrary. That's why he is calling this a notification. I don't know, but Anganwadi worker, helper, it is a voluntary service, and that is governed by the notification issued from time to time, and their service condition is governed by the notification issued from time to time. So, as per notification, 10 years is minimum service
Requirement.
qualification for promotion, and upper age limit is 45. And beyond, if it is the 44, then he will be, or she will be entitled. If it is 45, then she is not entitled. His case is this much. His age is 47 years. And now one notification he have issued, that is issued after advertisement. So it is not covered. 50 years, up to 50 years. I don't know, we are direct here one notification. That is the case value. So if it is necessary, I will obtain application.
No, it is necessary. That's why you have been asked to produce it.
Because there is no statutory rule, statutory act to appoint a Anganwadi worker and Anganwadi helper. They are only volunteer service and they are governed by the notification. Executive instruction that is issued by the government. So if there is a statutory provision, then he can say in statutory provision in our other service ballot, the upper limit is 60 years. And for lordship, know that the Supreme Court judges for 65 years, like that ballot. So it is here, it is voluntary service. It is governed by the notification, so there is no statutory rules and provision. That's why this limitation is to be service condition, and according to this service condition, their promotion, direct recruitment will be covered. That is the position.
What is this letter?
Notice by issue, otherwise, today I am handicapped because I have not received this notification. But it is 51 whether there is available or not, I don't.
My lord, we have also made a search, my lord, but that notification has been reproduced in a judgment passed by this honorable court.
Okay.
My lord can have a look at that part, my lord. Like copy na mark kyo korte hai?
Furnish a copy to Mr. Sutia.
My lord,
Okay, Mr. Sutia will furnish you one Xerox copy.
man.
Oh, yes.
Okay.
Lord, as per that,
Order. One more thing about page 37 and page 20. So I have some doubt regarding this matter. Number 4, 37 lordship value C,
the office order, is the serial number 3 against the 163 number Baguti Roman 3 on the party station. So in the advertisement, it is not mentioned. Mala. I don't know whether it is the same or not. Mala. The one on the same. In page 20, the advertisement shows 163 number BSDODI Baguti Anganbadi, but there is no 3 Romani. So best ballot Bhuya, he can clarify it, whether the same post or ballot is different.
No, no.
In But in office order, it is said ballot number 3. Roman 3.
Yes.
If it is not same ballot, there is no case. If it is same, then the ballot lordship can issue notice.
So yeah, let's not into it.
Lord,
Let's follow it.
but only thing, my lord, regarding this interim prayer, my lord. Appointment date is done for it.
Private respondent so ballot article under 3 SPF.
My lord can issue notice on the interim also, my lord. If the private respondent appears, my lord, then on next date, my lord, may.
Yes, yes.
Heard, sorry,
Then
heard it. That also heard that editing the new government advocate for the content. Heard.
We have to move to go.
Yeah. Reported. Case 3 judgment to
In this petition, started to put the constitutional topic, select the final selection list dated 8/9/2025, as well as the interim order of proposal dated 10/9/5. So we noted here that by the office order dated 8 September 2025, the child development project officer Corbetta ICT Corbetta has published the election final selection of 3 candidates. So yeah,
my lord.
where is the order of promotion dated 10/9?
Yes, yes, this is the, my lord, the last page of the writ petition, my lord, page 43, my lord, 42. 42 and 43 is the translated, my lord, and it is issued in vernacular officially, my lord. Page 44. লর্ড যাতে অনুমোদন মৰ্মে আবু যোৱা তাৰিখে শিশু উন্নয়ন প্ৰকল্পত অনুষ্ঠিত হোৱা বাছনি পৰীক্ষাত আপোনাক 163 নং বাগদি অংগনবাদী কেন্দ্ৰত অংগনবাদী সহায়িকা পদৰ পৰা অংগনবাদী কৰ্মী পদলৈ পদোন্নতি স্বেচ্ছামূলক সেৱা আগবঢ়াবলৈ নিৰ্বাচিত কৰা হৈছে। পেজ 44
Right. Order dated 10/9/2025. The child development project officer Corbetta has issued the order of promotion by which the number 5. Oshuara Khatun is promoted to the post of
অঙ্গনবাদী মিলন ওয়ার্কার
Anganwadi
কর্মী
worker from the post of
Anganwadi helper, my lord.
Anganwadi helper. Anganwadi helper. Filed the petition under the record and also filed the order dated 8/9/2025 and also the order of provincialization. That notice be issued to the responsible for it. Is the plea taken by registered post
Mark.
and also by usual process. Additional aspects services also part of it. Respondent, which was filed on affidavit for this part. However, no further notice is required to be issued to the respondent or post. Yeah, entered evidence. However, it's very requisite copy of the petition to be parties to include in the course of that. Also issue notice to the respondent with respect to the incident there. Please the matter after for it.
Mal.
For Mr. Sutia, you both protest notification?
Yes, yes, yes.
Timing items.
Okay. My lord, interim may be considered on the next date.
Okay, next.
Mal. Not.
Interim there will consider next return.
Timing items.
Obliged. Hello.
11 to 15.
May I please, your lordship, fix this matter after 2 p.m.
In this matter,
So
after
till
receiving the proposal,
we have no cases.
Please, after lunchtime, my senior is lagging on other court.
no, my lord, actually instruction is awaited here. After receiving in AGM Nazimuddin Ahmed in this matter, my lord, WBC 126/2025. After receiving the proposal from the inspector, the Director of Secondary Education has sent the proposal to the secretary, and the rest of the matter, my lord, instruction is still awaited. So sometime may be granted. In rest of the matter, already proposal has been sent by the director to the secretary.
Yes,
Sir, my lord, my lord, yes,
let the instruction come on next day.
Yes.
my lord, please, let my senior come.
No, your presence of your senior will not change the legal position or the factual position.
Okay, your honor, as you deem fit.
Because they have already sent the proposal. Furnish a copy to him also.
Yes.
Heard, Mr. Your name, please?
Jad Hussain.
Jay?
Jad Hussain.
Jad Hussain, Learned Counsel for the petitioner. And also heard Mr. Sharma, Learned Standing Counsel for the respondent in Secretary of Department. Mr. Sharma, during the course of hearing has produced one letter dated 25/9/2025 issued by the director to the secretary to the government of Assam. And a perusal of the aforementioned letter indicates that the director has requested the government to accord necessary sanction for a sum of rupees 4,77,700 63 rupees. Towards the arrear salary of the petitioner in WPC number 1261 of 2025. And under such circumstances, Mr. Sorma submits that the matter is being processed and he tries for this the matter after vacation. After vacation. Accordingly, it is provided that this is the matter immediately after reopening of the vacation. Then in the meantime, Mr. Sorma advised on the obtain up-to-date instruction about the status of the letter dated 25/9/2025. The letter produced before the court footage shall be marked as annexary and submitted with the record. And in other petitions,
My lord, instruction is still awaited, right?
awaited. Or Mr. Department of Mr. User for the responsible for this. Mr. Formal submits that too. He was directed to obtain inspection. The inspections are still awaited and in place for the matter of verdict. There is accordingly allowed. This is a matter of verdict. So in other cases also the proposal was sent.
Already sent, matter.
Already sent.
Yes. Already submitted to the secretary.
How about so Sorma submits that the proposal in respect of the other petitioners have also already been submitted to the secretary by the director elementary
Secondary.
So sort of the update up to that and appraise this court on next day.
Timing item 16.
I'm appearing for the PhD department.
Pardon?
I'm appearing for the PhD department. Lordship. As per telephoning instruction, Lordship, the petitioner is likely to get his salary, arrear salary, within this October month.
Will be released in the month of
October month.
October.
Yes. It is the telephoning instruction given by the Executive Engineer Society.
Executive engineer.
Society.
So date may be fixed, madam, last
Last part of
the
part
October.
of November first week.
Oh, yes, yes. November first week. That will be better. Yes.
Third, Mr. Desarma, learned counsel for the and Mr. Fora, learned counsel appearing on behalf of the Group, the technology for the case. PhD. Mr. Fora, obtaining telephonic instruction. Apprise this court that the petitioner will be paid the arrear salary
Well,
for the month of
my lord,
February
for
2016 and February 2018.
18.
2 months.
February
2 months.
2016 and February 2018 with the salary in the month of October. With the salary in the month of October. The salary for the month of October. And accordingly, he tries for this matter in the first week of November. Taking of the submission of cards for the card, provided that this is the matter on
10th November.
10th of November.
Well, obliged.
Coming item 70.
But this matter was fixed for instruction.
Well, if this person was appointed on 7/6/2023, then Lord, if he was released to join the office of the Deputy Commissioner on 12/6, that is after 5 days. And after 4 days, Lord, he got arrested, himself arrested. I mean, on 16/6, he was arrested. And released on bail, Lordship, 11/8/2023. In between, Lordship, he was suspended with effect from 16/6/2023. And till date, Lordship, no review or any DP has been initiated against him. No DP has been initiated. And secondly, Lordship, no review of the suspension order has been done. And the basic reason for not doing so, Lordship, till date, the office has not been intimated about his release on bail. That is the reason. Now, after receiving this copy of this writ petition, Lordship, if Lordship comes to the last two lines of the first paragraph of the instruction, the undersigned has already initiated the steps for initiating and departmental proceeding against Deepak Thapa and also for reviewing the suspension order set 16/6/2023.
So more than 2 years,
Yes.
the suspension order has not been reviewed.
Yes, Lord. In fact, Lord, if you work in my office, Lord, if only for 5 days, 6 days, Lord.
Whatever may be the date.
But Lordship, there is a judgment, Lordship, why I am trying to emphasize, Lordship. One judgment, Lordship, from which date this period of 3 months will be counted. Only 3 paragraphs.
No, from the date of team suspension.
No, Lordship, yes, that is, if he is in custody, Lordship, it is not possible for us to serve him a copy of the so-called.
Why?
That is the judgment is all about. If Lordship comes to just one paragraph, Lordship, if Lordship comes to last paragraph of paragraph 20, last paragraph of paragraph 20, 2G. Paragraph 20, Lordship, last paragraph. Now, the question therefore arises that when both mentioned conditions, these are the conditions for, can be taken into consideration by the appointing authority. In the opinion of this court, these conditions above noted can only be taken into consideration when the delinquent officer employee brings the fact that he has been released on bail or otherwise not in any custody or imprisonment to the appointing authority who has the power to vacate the successor. Now we have, after filing of this writ petition and after receiving a copy of the writ petition, now it is known to the authority that this person has been released on bail. Now they are going to initiate the process.
In that case, your lordship may kindly see paragraph number 21 of that judgment. May I read, lordship? Now coming to the instant case, it would be seen that it was only on 7/12/2022 that the petitioner was released on bail. There is not a single mention in the writ petition to the effect that as to whether the petitioner had informed the appointing authority that he has been released on bail. So because of this particular reason, this particular judgment was passed by this.
Did you inform the authority?
Yes, lordship. Your lordship will find that at page 26 is the type copy, 27 is the copy which was submitted before the respondent number 3.
Lordship, may kindly see page 27.
27? Yeah.
Is it an intimation, Lord? Whatever may be the content of, is it how an official letter is communicated?
Lordship, how can we expect a formal letter by a chowkidar, lordship? This is not a WhatsApp message.
This is a WhatsApp message.
And this is what is clicked by the petitioner, and that is why the date is reflected.
No, Mr. Bora,
Lordship.
where is the proof of submission of this letter to the appointing authority, the disciplinary authority?
No, that is not there. I accept that. I admit that that is not there. But in my paragraph,
How do you establish that this letter was received by them?
lordship, the petitioner resides just 1 kilometer away from the office of the respondent number 3, because his father, the petitioner's father, he works under the deputy commissioner's Tinsukia. So he stays in the circuit house. Lordship, there is no reason for the petitioner to not to inform the respondent number 3 about his release. On 10/8/2023, he was released on bail. And on 16/8, he went to the office. This was not, there was no endorsement to the effect that this was received, but this was received by the junior assistant of the respondent number 3. And that is why I have made a categorical statement in my para number 7 of the writ petition that the junior assistant of the office of the respondent number 3 had received it, but without putting any seal and signature. A person who resides just 1 kilometer away, Lordship, there is no reason for him to not to inform the respondent number 3.
No, that is only assumption. But there is no seal, no signature of receipt of this intimation by the authority.
On the other hand, Lordship, paragraph 11 of the petition, where he states, on 23/7/2025, the petitioner visited the office of the respondent number 3, wherefrom he collected the impugned suspension order, as the said suspension order dated 16/6/2023 was not furnished to the petitioner since his release. So from August 2023, he first time visited the office in the month of July 2025, and first time he came to know that one suspension order was issued against him, which was not communicated to.
For that reason, your Lordship may kindly see
From
para 7.
2023 to 2025, July 2025.
And for the last 2 years, they had not paid my subsistence allowance. They put me under suspension.
That instruction is also there, Lordship, may kindly see. Last paragraph, Lordship. Moreover, it is
Had
also
they paid my subsistence allowance, I could have approached them. I could have
then he
known
cannot
that I
receive
was under.
subsistence allowance, Lordship, and the reason is there. It is also submitted that no subsistence allowance has been granted to the petitioner till date. This is because the petitioner has not completed the mandatory NPS registration process, which is a prerequisite for initiating the first salary proposal. As a result, this division was unable to process the release of subsistence.
No, Mr. Nayak. This subsistence allowance and salary are two different.
Yes.
So allowance is allowance.
No, Lordship,
That is
Lordship,
a decision of the paper.
immediately after joining my office, Lordship, after 5 days, he joined the office of the Deputy Commissioner. So his files were transferred to the office of the Deputy Commissioner. And as his service was requisitioned by the Deputy Commissioner, everything went to the office of the Deputy Commissioner. So nothing, no formalities could be completed after his joining in the office. Even he was not even released the first salary.
No, on that count, you cannot deny him subsistence allowance.
No,
that
he has not yet been released the first month salary.
No, not necessary.
No, Lordship, for releasing the first month salary, Lordship, there are certain formalities to be fulfilled. In this case, Lordship, even his first month salary has not yet been released. So whatever formalities are there, let these formalities be completed, then authority will definitely process his subsistence allowance. We have no objection to that. But only, Lordship, before that, Lordship, let us initiate the departmental process. Let the authority have a review of the suspension, Lord.
No, that is not the object of granting the subsistence allowance. You first have to pay the subsistence allowance. Thereafter, to whatever you like. In accordance with law, that
A
would be
person whose first month salary has not yet been released.
No, that is it. That is your responsibility.
No, those who will complete those formalities, Lordship.
You issue notice to him.
Lordship,
He will appear in the office.
Lordship may say,
Complete the format.
Lordship may say, Lordship say that.
In view
So
of
as there is no question of releasing him salary at this stage, only the question of subsistence allowance. For that also certain formalities has to be fulfilled, not completed. So let us.
in view of the fact that Lordship, the respondent has a duty to fulfill the prescribed formats or the paperwork. In view of that fact, Lordship, they also owes a duty to review the suspension order. Once, if they had called me to their office to do the paperwork for releasing my subsistence allowance, that this person, if we assume that on 16/8 he did not appear, he would have certainly appeared before the respondent number 3. After 16/8.
So he went to the office only in the month of July 2025. This is his own submission
No.
in the paragraph 11, first line.
For that, your Lordship may kindly see para number 7. On 16/8, when I went there, I was not aware that I was placed under suspension. Para number 7, Lordship.
So it doubly clears, Lordship, that on 16, he never went to the office of the executive engineer. If he is not even aware till July 2025 that he was put under suspension, then how can he say that on 16/8/2023 he went to the office of the executive engineer? Definitely he would have been informed, Lordship, if he had been placed under suspension.
In that case, may I take your Lordship to page number 22 for a moment? This letter was issued by the Deputy Commissioner and District Election Officer Tinsukia. The memo number is at the top of the page. In view of case filed against Deepak Thapa so-and-so, division who was attached to this office while order number so-and-so dated so-and-so is hereby released from office of the Deputy Commissioner Tinsukia Election Branch, Tinsukia on 16/6/2023. Further, Executive Engineer PWD Tinsukia District Territorial Building Division is directed to take necessary action as per rules admissible. Now, this letter was issued on 17/6/2023 and the same was communicated to the petitioner. At page number 23, your Lordship will find the interim suspension order. The interim suspension order has was passed on 16/6, which has a reference of the letter dated 17/6. At the top of the page, the contents of the letter dated 16/6. It is a reference to the memo number issued by the district commissioner. Now, when the letter was passed on 17/6, how they have passed this order with reference to the 17/6 order on 16/6. And this suspension order was not communicated to him. If your Lordship may kindly see copy to information. This was issued to the Chief Engineer, Superintending Engineer, Deputy Commissioner, Treasury Officer, concerned file for record, Bill Assistant.
Oh, after being released from the jail,
Lordship.
you have not received the salary, and whether you have inquired from the office that why you have not been paid the salary, and whether you have reported for your duty after releasing from jail.
That your Lordship will find page 27. He went to the office since he was not aware that he was placed under suspension, so he filed an application stating that he may be allowed to join his duty.
Mr. Nayak, Lordship, can I obtain inspection as to whether the office has received this letter from the
One line is there, Lordship. However, no such information has been received till date about it release on bail law.
Where it is mentioned?
In the middle portion, Lordship. Nor any departmental. This division Tinsukia has not yet received any intimation by Deepak Thapa that he has been released on bail by the concerned High Court. Furthermore, a request has also been made to the Superintendent of Police, Amren Division, for a duplicate copy of the FIR and related documents concerning case number so-and-so. However, no such information has been received.
He was arrested in Amren.
He was arrested on 16/6. From 16/6, he was released on 11/8/2023, and he is saying that on 16/8/2023, he went to the office of the executive engineer to join service, and he submitted this letter. But on that day, nobody informed him that he has already been placed under suspension. That is after 3 months, 2 months.
No.
And in paragraph 2011, Lordship, it states, in July 2025, he went to the office. The first time he came to know that he has been placed under suspension, and accordingly, he obtained a copy of the suspension.
No, Mr. Nayak, see the suspension order.
Yes. If Lordship,
Copy of the same is not marked to the petition.
maybe Lordship will clearly try to understand the provision of law, Lordship, that is 6(2), Assam Discipline and Service. Lordship, this suspension under Rule 6(2) is a deemed suspension by operation of law. And the law settled by the Supreme Court is that even if no formal order is passed, putting him under suspension, he will be considered under suspension from the date of arrest if he is already in custody for more than 48 hours.
No, that's all right. That is there.
So,
But
no,
are
what
you
I'm
not,
trying to emphasize,
are you not supposed to communicate the
no,
suspension order to?
if without passing a formal suspension order, somebody can be placed under suspension, there is no question of communication. And he is saying that on 16/8/2023, he went to the office of the executive engineer, but nobody informed him that you have been placed under. Is it believable, Lordship? You are the employee of that office.
No, maybe. It may be believable because this suspension order itself was not marked to him. Is he not entitled to know that he is placed under suspension with effect from the date of his arrest?
That is why, if it is by operation of law, Lordship, in that situation,
that's all
Lordship,
right. You have
formal order
power.
is only for the office purpose. Lordship, on that count, Lordship, I can place judgment also. It is only for the purpose of official record. It is not even required to communicate. If it is deemed suspension, Lordship, if it is a legal fiction, what is the requirement, Lord? It is the law.
No, that's all right. But this communication of the suspension order, is there any judgment?
Supreme Court says, if it is a deemed suspension, no formal order is required to be passed. Even no formal order is required. If it is the formal order is
No,
not even
but
passed, then also
Mr. Nayak, you see here you have passed the order.
Yeah.
But are you not supposed to communicate this order to the petitioner?
no, that is why I am submitting again and again. If you really went to the, I am not aware whether you have been released on bail or not.
No, forget about his
Lordship,
reporting to the office or
Lordship,
not.
till date, I am not aware. Till the filing of this writ petition, I am not aware whether you have been released on bail or not. And if you are saying that on 16/8/2023,
No, that
you went to
is,
the office,
no, now the question is you have not communicated the suspension order to him.
Lordship. No, at this stage, Lordship, as I am aware now that you have been released, I only need to issue a so-called notice within 90 days from the date on which I became aware.
Being the head of the office, are you not supposed to inquire about the status of the petitioner?
I inquired with the police officer. Lordship, I kindly see one line. Furthermore, a request has also been made to the Superintendent of Police, Hamrin District, for a duplicate copy of the FIR and related documents concerning case number so and so. However, no such information has been received yet. Lordship, law has been settled in the Raffiati judgment. Lordship, I kindly see. When I'm supposed to become aware, Lord. On being intimated by the person concerned that I have been released on bail. And my 90 days start from the date of intimation. Lordship, even if it is, I became aware only from the writ petition, Lord.
Now, with all respect, Lordship, Raffiati judgment always says that that intimation has to be given by way of a representation or application. Once a person who got released on bail, appears before the authority physically, that intimation covers, Lordship. And therefore, it owes a duty upon the respondent to review the order. It is not necessary every time that a person has to file an application in a proper format. Because these are chowkidar, these are great for employees.
The line the court has said, in the opinion of this court, the conditions above noted can only be taken into consideration when the delinquent officer employee brings the fact that he/she has been released on bail.
That bringing of fact will come into play once he appears physically.
You at least go to the office, meet the officer. He is stating himself that I went to the office only in the month of July 2025. And how can you become aware about your substance? Lordship will issue notice at this stage, Lordship.
Because once, Lordship, there is another proposition of law that once disciplinary proceeding is also started, they have to review by giving a reason.
Disciplinary proceeding has not yet
No,
started. We have not
by
even
giving a
issued so-called.
reason. Here, firstly, there is no review. No, why no review has been done? No reason has been explained. Because Apex Court in Deepak Mali and other cases also says
Deepak Mali
that,
don't mention, please. It's a TCS group. Deepak Mali do not apply to the Assam state.
Lordship,
Only paragraph is paragraph 21 of the Ajay Kumar Chaudhary. Ajay Kumar Chaudhary says, issue so cause within 3 months, or the suspension will go. And if the so cause has been issued, review the suspension order, pass a reason by passing a reason order.
did they do
So
it?
now we are issuing a so cause, and we will immediately pass a reason order.
No. Even if the so-called notice is not issued to the delinquent officer or staff, are you not supposed to review the suspension order?
If the suspension or if the so cause notice is not issued within 3 months, Lordship, the suspension order will go. That is Ajay Kumar Chaudhary. There is no question of I am not issuing so cause, but I am extending. That is not the question. If I have issued the so cause within 3 months, then I am required to pass a reason order. But for the second part, Lordship, for passing a reason order, no time frame has been fixed. Nobody will try to interpret the judgment,
Once
Lordship.
you have passed the suspension order, it will continue for indefinite period. Is it the law?
No.
No, that is not the law.
Then?
That is not the law. Ajay Kumar Chaudhary will also apply in case of 6-2 also. But only rider is you have to inform me so that I can issue a so cause. That is not my submission law. At this stage, it cannot be said as it's a law, Lordship, that has been settled by a coordinate bank. From the date of intimation, within 90 days, I have to issue a so cause. And if I fail, then your currency of suspension will not exist. You will find yourself reinstated. That is the law, Lordship. So as I have become aware only after passing of this filing of this writ petition, now I am aware. You never intimated. I am aware now. And now I am going to act, Lordship, in terms of Ajay Kumar Chaudhary and in terms of representative. That is what I am.
No. Even if you not initiated departmental proceeding against him, are you not supposed to review the suspension order?
No. Lordship, if I have Ajay Kumar Chaudhary, Lordship, I am just reading 3 lines, Lord. Paragraph 20, I'm reading slowly. We therefore direct that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charges sheet is not served on the delinquent officer employee.
So in his case, you have not served it.
No, from which date this 3 months period will start. For that, Lordship, I'm placing the judgment passed by the coordinate bank. That is one part, Lord. If no so cause has been issued within 3 months, then suspension will not remain. Second part, Lordship. If the memorandum of charges sheet is served, a reason order must be passed for the extension of the suspension order. If the so cause is served, then a reason order must be passed for extension of the suspension. So second one is on the basis of the first. I have not yet issued the so cause lot.
So you are not entitled to review his,
So review portion will come later, Lordship. Now let me issue the so cause notice. Let me start the departmental proceeding, and immediately after, for second portion, Lordship, no time frame has been fixed. The only word is immediate. So let us issue the so cause. Immediately I will review his suspension and pass the reason order. And these 3 months, Lordship, Ajay Kumar Chaudhary, if Lordship, one paragraph, Lordship, in the Rafedali Lordship. 3 lines of, if Lordship comes to last few lines of paragraph 18. Just the last 5 lines of Ajay Kumar, paragraph 18. Last 5 lines. Thus, the judgment of the Supreme Court also do not deal with the question as to how a person in custody or imprisonment can be served with a memorandum of charges, or for the matter whether the delinquent employee would have a reasonable opportunity as required under Article 3112 of the Constitution when the delinquent officer is in custody or imprisonment. From which date this period of 3 months will start, that issue was not touched by the Supreme Court. And that is why the scope of interpretation was.
that CCS rule. Here it is provided.
But in CCS rule and state
It is
rule are
provided.
different, Lord.
No, maybe, but
Proposition would be.
law is
Yes.
almost same.
Not same law. In CCS rule, it is specifically provided. If you do not issue search sheet within 3 months, then suspension will go. That is there. That provision is not there in the Assam. That is why the interpretation was, that is why the Rekibuddin judgment was referred to the division bench court, wherein it was decided this Ajay Kumar Chaudhary judgment will also apply in case of 6-2, that is deemed suspension. That is why it was there. And now we are following. But that date, that calculation of that 3 months, when from when this 3 months period.
No, it may not be in the some services discipline and appeal rule, but it is provided in the CCS rule. Why we?
The CCS rule would not apply in case of.
No, that's all right, not apply, but the position of law.
Position of law different, Lordship. In case of the central government employees, Lordship, that rule will apply. In case of our case, Lordship, our rule will apply. But that is not under dispute, Lordship. I am not disputing that fact because Rekibuddin, the Ahmed judgment has clearly stated it was referred to the division bench. Division bench says no, Ajay Kumar Chaudhary will also apply in case of 6-2. That is
Saying that
suspension like the petition.
review has to be done within 3
That is not
months.
the issue, Lordship. Issue is only here when I was intimated and where from when this 3 months period will start.
Okay, we will list it for further consideration. In the meantime, you release his subsistence allowance.
Subject to fulfillment of the necessary property.
That is your burden.
No, on some.
How can you do it?
In
It
case
is
of
your
other-
responsibility.
it-
Order of this court is that you release it and you produce the document of
At least
release
consider my difficulty.
before this
Lordship will
court on
consider,
next day.
Lordship will in case of other employees, Lordship, it would not have been a problem now. In this case, it may create some difficulty
So
because.
you should
no
not sue him. You complete the formality.
Yes.
But,
Let him also approach the office, Lordship. Let him go to the office, meet the officers, Lordship.
how can you do it? It is your responsibility, but you have to produce the proof of payment of subsistence allowance before this court on next date. Okay, take that.
May I humbly submit that suppose Lordship a peon or a chowkidar, he does not know what is there in the Rafedali.
There is no
Okay,
question of ignorance.
We'll again hear on this point.
Yes. He may not know, he may not have gone through the Rafedali judgment, Lordship.
Pardon?
A chowkidar
That's
or
all
a
right.
peon,
We'll
yes.
consider it on next date.
On 24th October.
How do you set your?
Okay.
17th October.
Take up in the first week of November, Lord.
First week of
Lordship has
November,
already passed the direction, Lord.
pardon?
Lordship has already passed the direction that to release this. There is no
No,
question.
that's, we are also concerned with this, suspension order. Out of
CP Lordship, in the meantime, I will issue my, I initiate my proposal.
November first. No. November first week, this court will not be available. 24th.
Then Lordship may kindly take up towards the end of this, so October, Lord.
Till 24th. So 24th October.
Right.
Any other matter? Who will pass the order?
Lordship.
Timing item 20 for orders.
I'm sorry, Malo, I'm appearing on behalf of B. Kostik, Malo. He was there in the morning of Malo due to some personal difficulty.
On behalf of?
B. Kostik.
Lordship.
He left the court due to some personal difficulty. He was there in the morning of.
May I please, your Lordship?
Immediately after vacation.
In this case,
Any
Lordship,
day, Malo,
repeatedly, Lordship, a respondent taken time in this
No, no.
case.
No any malicious intention, Malo. Only genuinely praying, Malo.
Kindly peruse the order dated
Immediately after
8/9/2025,
vacation, Malo, any day, Malo.
Lordship. Thereafter, again, they were taken time, Lordship.
If on reopening, Malo, if we will fail produce any inspection, Malo.
Okay, 30th, 30th. Third Mr. R. Ali.
M. Hussain on behalf of R. Ali.
M. Hussain, Learned Counsel, preparing behalf of R. Ali. Start. Ikebora.
On behalf of B. Kostik.
Behalf of B. Kostik. Learned product. Mr. Bora submits that Mr. Kostik is B. Kostik left the court premises and he tries to after the open. There is a lot of hurting. The required information. Person ordered it at 22nd of September 2025 shall be made available on 13th of October.
Item fixed at 2 p.m. Item number 22 for order.
Hello, here I have bring the inspection. I have placed it before your Lordship. Now, my lord, only government has to, my lord, create a force, my lord, that is personal, my lord. That has to be done by the government. Department has, my lord, director has already done that part. This, my lord, force of creation should have to be done by the government. That is, the remaining this part is there. He has to issue provincialization order. And all benefits with effect from 1/1/2024 in terms of some of the court order.
When this letter was issued?
Well, this was issued on 5th.
25th. Yesterday. But when the letter was sent to the government for creation of post.
My lord, then the third page is, my lord, the checklist as required by the, my lord, procedure, my lord. My lord,
When it was sent?
my lord, that is, my lord, sent on, my lord, 25th of
20?
September. Yes, my lord, immediately after vacation, my lord,
you produce the complaint for that.
My lord,
Don't know.
immediately after vacation. My lord, kindly.
Third Mr. Controller, Learned Counsel for the petition. Mr. P.K. Bora, Learned Counsel for the contest. Mr. Bora has produced a letter of the contender addressed to the address to the Secretary of the Assam Departmental for creation of post. The for creation of the post of tutor
Well,
against Sarangapur Purat 50 MES under Dhuri district. Person to decision of the SLC. Meeting held on 7/2/2024. With a copy of checklist number 9 with detailed financial implications with respect from 1/2021 to August 2025. That Mr. Bora, on the basis of the aforementioned letter, price for testing the matter after vacation. Where is accordingly allowed. Mr. Bora shall produce compliance order before this court on 17th October. 17th October. 17th of October. It is quite clear that no further opportunity will be provided the contempt to comply with the order of court.
obligement.
The
I am
letter
deep.
produced today shall be marked as Mr. Death and shall be taken with the record.
I am deeply obliged.
Item fixed at 2 p.m. for admission. Item 30.
Yes, they have filed our affidavit, your lordship.
When?
On 24th, your lordship.
We have also replied that.
Pardon?
We have also replied that of the fifth notice. In fact, Lordship, I am very much surprised, and now it is good that they have proved that as Falte, he was the respondent number 4 earlier. Now he is respondent number 3. He has been promoted. So he has submitted this affidavit as if like it is a private respondent, private people. So his blue-eyed boy, that as Falte is supporting his blue-eyed boy, that Chandra Dhos Panda, whom he has made accountable manager, and bypassing all the my privilege as an owner of the college. This college is also, it was established by me, but it is the asset of entire Northeast.
Okay, please.
Your lordship, he has filed a reply, but it has not come in on record, your lordship. So I have filed my affidavit.
You have received the copy?
Yes.
The copy of the reply?
Reply I have received.
That reply is available on the record.
It is record. Is that correct?
No.
Now, what is your stand in respect of the interim chair?
Interim, your lordship, lots of allegations are there against the petitioner, your lordship. He is not, I have mentioned in paragraph number, your lordship, 9, your lordship. In page number 98, yes.
Yes.
I am reading, your lordship, that with regard to the statement made in paragraph 7 of the writ petition, the deponent begs to state that office of the TAW Guwahati has received number so and so, dated 9/9/2024 from the training manager of TAE, wherein it was informed that Mr. Vikram Sinha law firm creating troubles and problems to run the course and harassing the management teams of institute. In this regard, he has attached the deed of agreement with Vidya Bharati Educational Trust, Gunupur, Orissa. He stated that as per the agreement clause number 16, Mr. Bikram Singha law firm will not cause any harm with regard to running of CAE, but he is blocking some of the rooms in CAE building which are used for AME training purpose. He further stated that as per clause 7, Mr. Bikram Singha law firm has agreed to support in all terms until change of location of present CAE, whereas he is pressurizing and threatening us to change the location by giving us letters mentioning to collect unjustified amounts, to use pictures and building, etc. In this regard, he has attached a letter from Mr. Bikram Singha law firm, wherein the petitioner intimated the chairman GIT University for payment of rent for running the institute at Guwahati, and informed that he has done the necessary inspection of the university premises, which is a prerequisite for shifting of the AME branch of CAE from Guwahati to Gunupur, Orissa. Further by letter number so-and-so dated 29/10/2024, Annexure 2, and another one, letter 22/11/2024, Annexure 3, the training manager once again intimated Office of the DTAW, Guwahati, that Mr. Bikram Singha law firm threatens them to change the location of the institute, else he will collect unjustified amounts along with interest for utilizing the facility. He also informed that Mr. Law firm has locked the labs and creating troubles to run the course. Mr. Bikram Singha law firm himself pressurized the management team to shift the students to Gunupur and leave the Guwahati facility. Annexures are also there, Annexure 7, Your Lordship. And he himself made, Your Lordship, agreement, Your Lordship, in paragraph number 7, Your Lordship. Page number 95.
Yes.
That with regard to the statement made in paragraph 5 of the writ petition, the deponent begs to state that GTCA had not advised, suggested for any agreement with the Bharati Educational Trust, Gunupur, Orissa. The petitioner himself suggested for such to run the institute due to ill health of the petitioner. Accordingly, Sri Bikram Singha law firm had signed the deed of agreement, deed of declaration acknowledgement, and deed of declaration with Dr. Chandra Das Panda, Secretary of Bharati Educational Trust, Gunupur, Orissa, to hand over the approval required facilities, infrastructure, and manpower of the College of Aeronautical Engineering, Guwahati, for difficulty in running of the same due to his ill health condition. In the deed of agreement at page number 4, para 3, and page number 42 of this writ petition, he himself annexed, Your Lordship. The Sri Bikram Singha law firm clearly mentioned that on the strength of this deed may establish GIT U College of Aeronautical Engineering with a new accountable manager to be nominated by the first party, and the first party shall have no claim whatsoever on the said business with effect from the complete execution, and henceforth the first party is no way liable, responsible for the affairs in connection with the College of Aeronautical Engineering AME part. In deed of agreements at page 5, paragraph 10, page number 42 of this writ petition, it is clearly mentioned that the first party, Sri Bikram Singha law firm, having full right to hand over the approval granted by the DGCA, hereby handed over to the second party, Bharati Educational Trust, and will not at any time hereinafter revoke, annul, and make void the aforesaid handing over hereby given to the said second party, or do or execute or knowingly or willingly suffer any act, deed, or thing whereby the said second party may be prevented from having and receiving the said approval or any part thereof. to and for his own use and benefit, or by means whereof the said second party shall be injured in the said business. That in next page, Your Lordship, 97. That in deed of the declaration acknowledgement, page 3, para 1, page number 36 of the writ petition, it is mentioned that in pursuance of aforesaid agreement and in consideration of sum of rupees 7 lakh, which the second party has made to the first party by check bearing number so and so, State Bank of India, Gunupur branch, Orissa. The second party, with respect to payment of consideration against handing over the approval license for running the aircraft maintenance engineering college, the first party hereby admits and acknowledges the sufficiency of the consideration price. And mentioned in para 2, the first party shall have no claim whatsoever on the said business with effect from complete execution, and henceforth the first party is no way liable, responsible for the affairs in connection with the College of Aeronautical Engineering AME branch. And also mentioned in para 3 that the first party shall hand over all his powers and privileges on aircraft maintenance engineering of College of Aeronautical Engineering to second party. It is clear that the first party, Vikram Singha Lahore, after receipt of the consideration amount in full satisfaction and handed over all his powers and privileges, approval license for running the aircraft maintenance engineering college to Vidya Bharati Educational Trust, Gunupur, being represented by Secretary Dr. Chandradhar Panda from the date of execution, that is on 2/3/2024, as per the second part.
Whether that agreement is a part of the record?
Yes, Lord.
Yes.
It is there.
Page number?
Everything is done according to the agreement only, Your Lordship.
Where is the agreement?
In the middle, he is claiming all this, Your Lordship.
It is Lordship, page number 33 onwards. Oh, page number 30.
Agreement 30, yeah.
Okay, if the affidavits are available before the court, then we'll proceed to hear the matter, finally dispose of the same
Yes, Your
immediately after reopening.
Yes, Your Lordship.
Lordship, here is, they have stated whatever, may I counter that? Already I have filed my reply affidavit. Lordship, this as Phalpe, now he is respondent number 3. Earlier he was respondent number 4. He has been promoted. He is having a nexus with this organization, these people. Lordship, that is a civil matter. We will not go into that. Whatever he is saying, Lordship, why I'm saying nexus, Lordship, I would like to prove it. That complaint, whatever just now respected counsel has stated, it is at page number 103, their reply affidavit, page number 103, kindly refer, Lordship. Here, there are three letter has been fabricated. It is afterthought. Why, Lordship? There are no official received stamp. Whenever a letter goes to the office, then immediately that receiving people, that clerk used to put a stamp and numbering. I can prove it, Lordship. It is there in page number 162. That is my letter. Page number 162, Lordship. Here on the bottom part, the stamp is there. Page number 162, Lordship, of their affidavit.
page number 162, bottom part, Lordship, will find there is a stamp. There is a DGCA stamp and that is 108 number, receipt number, and date 5/3/2024. File number GCAE. So it is their paper, and they have submitted where with a seal. And these paper at page number 106, where they have stated they have I have created a lot of illegality with my own college. Page number, they have annexed Annexure 1, Annexure 2, and Annexure 3. This 3 paper has got no such kind of seal. It is afterthought. Afterthought they have fabricated, Lordship. That is one. And second, Lordship will find at Annexure 1, page number 106, there are 2 officers' signature. His own junior officer, of course. So signature, 2 officers' signature, but at Annexure 2, page number 108, only 1 signature, that S. Valte's signature only. The junior officer refused.
Okay, Mr. Sinha,
Lordship, this is.
next that we will hear the matter and finally.
Lordship,
of the same.
Lordship, they are fabricating lot of things.
Okay,
They are,
we will see.
and this order may be stayed till next hearing, Lordship.
No.
Lordship, if it is not stayed, they will do lot of things, and
No,
that is,
on
Lordship,
that
on my
we will-
last occasion,
We will
last,
finally hear the matter.
Lordship, on my last occasion itself, when I filed another previous writ petition, I have already attached here. So during the hearing period only, the matter was hearing here and with other bands, and they have passed the order. They have passed the order, so that that time the Honorable Court did not stay the previous orders. That is why I had to again withdraw that writ petition as per the suggestion of the Honorable Court.
Mr. Sinha, this interim relief cannot be claimed as a matter of right. You
Lordship.
have to show the prima facie case, the balance of convenience and the irreparable.
Lordship, the students are really in danger, Lordship. All of the students are from the Assam, and they are suffering with, they have been forcefully shifted to Gunupur. Lordship, may kindly see there another.
There is one agreement also.
Lordship, agreement was there. Lordship may remember.
We have received some of rupees 7 lakh.
I have not received it, Lord. That also, that check also bounced. Lordship, these are the fact, Lordship. This check was given to me, but never been realized.
No interim relief. We will
Lordship,
finally hear.
Lordship may kindly go to another. The student's complaint has been sent to DGCA email.
The students are not a party in this proceeding.
Lordship, yes, but students are really suffering, Lordship. They have sent a email. They have sent an email that is page number 112. Lordship, may kindly their affidavit. Email sent to DGCA, and they have stated that they have completed their course by March. That is first paragraph, Lordship. We are writing to seek your guidance and assistance regarding an issue we are facing with the College of Aeronautical Engineering. That is, they have written this on 7th August 2025. So College of Aeronautical Engineering, Guwahati. We took admission with the college 2022 July-December session when Mr. Bikram Hingo Lokor was the accountable manager. When we were in 4th semester in 2024, Dr. Sandrodha Panda was appointed as new accountable manager of College of Aeronautical Engineering, and under whom we completed our actual environmental practical training AEPT at Shaurya Aeronautics Private Limited from 22nd January to 10th March 2025. There is one more problem, Lordship. this Saurya Aeronautics was not the, the students were sent to Saurya Aeronautics. They student were not supposed to send to Saurya Aeronautics. They were supposed to send to Air India. That time AIESL, a government organization. I have tie up with government organization at Calcutta as per the previous Honorable High Court's direction only. I had come before the Honorable High Court because of illegality of these officials. So these students have completed in March 2010, but till that day, they were not getting their course completion certificate, COFR, they were not getting. So they are suffering, Lordship. They are suffering, and present students classes were not conducted since January 2025, Lordship, 20th January 2025. If classes are not going on, Lordship, then how, as per civil aviation requirement, Lordship, no.
Mr. Sinha, we are not adjudicating the dispute between the students and the management. Yeah. Students are not a party.
Students are not party, Lordship.
Yeah.
Then how can I save my institute, Lordship?
We'll finally hear and dispose of the matter on next date.
23rd October.
Lordship, there will be lot of trouble, and there are lot of against this official. Lordship may kindly see one more paper that is at DGCA headquarters, Lordship. They have sent me a mail. That inspection has been scheduled at Guwahati only. It is another shocking, Lordship. I have downloaded. Lordship may kindly see. A lot of things are going on under. Lordship may kindly see page number 6 at serial number 16. Page number 6, serial number 16, Lordship. The college address is in Guwahati. The S-Valte is acting against their own. That is why I have prayed on last occasion that Civil Aviation Secretary supposed to file affidavit. They have not taken on last occasion. They supposed to take instruction from Civil Aviation Secretary.
Yes,
They have
regarding
not.
that I talked over telephone. They said they are just respondent number 1 is formal part.
No, Lordship. Respondent number, and that these officer was
This is the main year. They said they are respondent number 1.
Where is the paper, Lordship? It is not there. Nothing there. Only verbal submissions, all these going on, Lordship. It doesn't work like that.
I'll bring instruction.
And college address is still in Guwahati. And Lordship may kindly
In the
see.
meantime, you may file the affidavit on behalf of the respondent number 1.
Yes, sir.
Lordship may kindly see against this respondent number 3, who is doing all this illegality. These are the vigilance case. And I have also received letter from Vigilance Department.
We are not.
So these kind of activity is going on, and college students are suffering. I am suffering, Lordship. I am suffering. And Lordship, during my worst time, why I have executed this agreement to save the institute only, because that time I could not come to road. I was, in fact, Lordship, police has visited colleges, threatening me like I was.
No, Mr. Loper, there is one agreement. You may deny
There is
it
an
to me
agreement.
as
Lordship,
well.
I have not transferred. They also, Lordship may kindly see.
So,
there.
Mr. Sinha, we'll finally hear the matter and dispose of the same.
Lordship, till then, if it is, if it is not there, then again there will be multiplicity of
Maybe
proceeding,
we'll
Lordship.
see later on.
And
Heard Mr. Vikram Sinha law court.
Lordship, I have
Sorry,
not changed
person.
ownership. It is not there, Lordship.
Also heard Mr.
Ownership has not been changed.
Learned at CCC agreeing for the one. Spoken submits that he has filed affidavit in opposition on behalf of the respondent number 4. However, in respect of respondent number 1, Ms. Spoken submits that it has obtained verbal instruction, and as per her instruction, respondent number 1 is not a form, is only a formal part. However, Spoken is directed to file an affidavit in opposition in respect of the respondent number 1 of business that laid the matter on 24th. But first,
Sorry,
23rd.
23rd. 23rd October.
Yes. Obliged.
23rd of October, and on that day, an endeavor will be made to finally hear and dispose of the entire matter.
Obliged.
Item from production.
May it please, my lord. My lord, take up the case is that, my lord, appointment of Gauvra, my lord. One advertisement and was issued on 23/03/2022, my lord, page 16, my lord. Page 16, my lord, for appointment of Gauvra, my lord. Then petitioner applied, my lord, and result was declared on page 21, my lord. Page 21, my lord. And my name is in page 22. Serial number 33, last, my lord. Bonojit Padgiri, my lord. Thereafter, my lord, one applicant, my lord, filed complaint against me at Director of Land Revenue, my lord. Page 24, that is order, my lord. My appointment was set aside, my lord. Page 24. Yes, my lord.
Set aside by?
Set aside by the Director of Land Revenue, my lord. Director of Land Records and Service, my lord. Page number 27, my lord, relevant portion, my lord. Page number 27, my lord. Order, in light of the above analysis and upon perusal of the facts, circumstances, and evidence submitted, it is found that the appointment of respondent number 4, Sri Bonjit Padgiri, as government for charge number 13, Borba Makata, so-and-so, is unsustainable and due to pending TRC case number so-and-so at the time of selection, violating clause 9 of the advertisement dated 28/3/2022 and clause 162(2) of the executive instruction. The police verification report oversight does not cure this defect as confirmed by the court documents. Despite respondent number 4 higher interview marks, the criminal pendency disqualifies him priority in integrity and legal compliance for efficient village administration.
One case is pending against you.
Yes, my lord, that is, my lord, TRC case, my lord, that after that this case was withdrawn, my lord.
Pardon?
Withdrawn, my lord. That case was withdrawn, my lord. Later on, my lord.
Where is the withdrawn order?
No, withdrawn order is, my lord, I have not annexed, my lord. My grievance is not that, my lord. My grievance is that, my lord, after that I have filed review petition, my lord, before state government, my lord. There is a law, my lord, 162.
162 of?
162, my lord, yes, my lord. 162D, my lord. Executive instruction of Land and Revenue Manual.
Is it part of the record?
Yes, my lord. I have, my lord. No, my lord. In my representation, I have, my lord, given all the text, my lord. Is that it? Yes. That is- One 162B, my lord. Test 49, I have specific, my lord. Statement was given regarding this law, my lord. In
140?
49, my lord. 162D, my lord. Is my page number 49 of petition. 162D, what is law, my lord?
A petition for review of the order of Director of Land Records and Surveys, Assam, shall lie to the state government within a period of 90 days from the date of receipt of the order by the applicant. The state government shall, on receipt of such application for review, shall give reasonable opportunity of being heard to the parties likely to be affected, and thereafter may confirm or set aside the order of the Director of Land Records and Surveys, remit the case directing him to take such further action or inquiry as it considers proper in the circumstances of the case, provided the petition this is not relevant. My grievance is that, my lord, during pendency of my review petition, my lord, it was not heard by the, my lord, state government, my lord. Then, my lord, Deputy Commissioner, impugn order annexure 5 page 51, passed an order my cancellation of appointment of Gavura. As per law, my lord, there is a review petition before 90 days, my lord. And after that, confirmation order will be, my lord, sustainable of the Director of Land and Record. That is my case, my lord. My review petition is pending, my lord. It was not heard. Now, my lord, on 24th, my lord, the Deputy Commissioner passed an order.
Whether the Deputy Commissioner
Page 51, my lord.
is aware of about pendency?
Yes, my lord. Yes, my lord. That is representation, page 49, my lord. On 23rd, I have filed and received copy also done by the Deputy Commissioner. Page 49. And thereafter, they have passed on 24th this order, this impugnment.
Where is the advertisement?
Yes, my lord. Page 16, my lord.
11 to 17. Number 9.
Yes, ma'am.
There is a basis, my lord. The applicant must not be involved in any criminal activity. During the period of selection, he was involved in the criminal activity. That was not exposed by him without prep in the application. That's why the other part where he was selected, ignoring this clause, then other party hired an appeal before the Director of Land Records. Director of Land Records, after hearing all the things, pass the order, yes, this selection is yours the rule, yours the structure. That's why that is set aside. And pursuant to the set aside order of the Director of Land Records, the page 51, Deputy Commissioner is bound to pass this order. And accordingly, he followed the order, he removed from service. Now, question is, now it is a dismissal order. Removal with disposal order from the service. The motion stage, my lord, apart from issuing notice, my lord, motion stage, it says, my lord, this order cannot be stayed. Because testo is there, my lord, it amounts to be there, allows this thing there. That is the bottom line. I am citing this citation of the Supreme Court. The citation is slightly, my lord, to some extent of page or something is wrong, but not to penalty is. Let's go first. Sandeep, by name, I will say the person now this immediately I cannot do it. I will speak. The citation or page number something is wrong. I have just print out one case of this one.
It's number
10, my lord.
Number 10.
10. Number 10, my lord, this SLP number is there. I dispose of 89 to 9. They said at a motion stage, the special order cannot be stayed by the
But here the
Yes.
word used is termination.
Yes,
Termination, that is removal from service, this is amounted to dismiss, my lord, is removed from service, already been removed. And at this circle officer is holding the charge of the, so at this stage, my lord, if it is stayed, the amount is to my lord, granting the main payer. The main payer is to set aside the appeal order and the deputy commissioner's order. That's why I'm notice my issue, we will obtain instruction to file affidavit if necessary, my lord. And other party, private respondent is to be appear. Because his cancellation order has been passed by the deputy commissioner pursuant to cancellation order of the director of land record. The deputy commissioner is the subordinate officer to the land record. And hearing, my lord, he filed a review petition before the chief secretary. Chief secretary is not a party in this petition, and plus chief secretary is not a forum. It is the principal secretary of every department. He is the appellate also.
Appellate.
Yeah, that is the wrong also, my lord. He has not appellate is a party. How lordship will educate the matter? That's why, my lord, notice my issue. If my lord, paid him party or not, it is up to him. But in this instance, my lord, no interim order. Lordship only issue notice.
no, my
Because
lord,
it's dismissal matter.
as per my lord, this rule, my
Law
lord,
is says, my
for
lord.
state government, my lord, chief secretary is the head of the state government, my lord. I,
No, no, no.
No, that is all right, but
Chief
yes,
secretary
my
is not. The particular department, political department, revenue department, PWD department, there is a person at the post.
they
who is
have,
the appellate
they have
authority.
received, my lord,
The
in various
principal
cases, my
secretary.
lord, they have received and later on, my lord,
no,
that is-
they may receive it, but
yes, my lord, and later, my lord, they have called for hearing, my lord. I have filed, my lord, several cases before chief secretary, then additional, then divide to additional chief secretary, my lord. Mainly to, only for chief secretary, I have to address my, not principal secretary.
No, no, chief secretary is not representing the appellate authority.
no, as per rule, who is the appellate authority?
Appellate authority, principal secretary, revenue department.
Principal secretary.
Now,
No, my-
additional chief secretary is holding the charge because he is out of state.
Yes, additional
So
chief.
therefore, he has been
Yeah.
hearing the matter.
Now, here,
Okay.
he is not made party also, my lord. Appellate authority should party. Then, my lord, whatever.
No, my lord, this is
No,
not,
no, no, it is not a law.
If-
Law
yes,
is
my
says,
lord.
my lord, dismissal order, terminal order in motion stage, at least. This citation is there, but I have not heard it, but perhaps some printing mistake is there.
Okay.
no, my lord, one submission, my lord. What is the value of review petition if not state, my lord? They have to, I have filed review petition, my lord. They have to pass some order. That, my lord, in law, my lord, after 90 days, my lord, that order will be confirmed, my lord. As per 162D, my lord. I have no grievance against chief secretary or therefore he is not a party, my lord. It was my grievance only for deputy commissioners, my lord, order, impugn orders 24. I will heard, my lord, both the parties will be called, my lord, then hearing will be start, my lord. Without hearing, my lord, there is, both the parties should be, my lord, prefer, my lord, for hearing, as per, my lord.
If he is success in
Yes,
the
my lord.
review, then automatically he will get it.
How
If
can,
he
my
has
lord, that is,
success, my lord,
this
he will not
order
get
has
it.
no.
Mayor is
lord.
staying this order.
If I
amounting to-
succeed, my lord,
amounting to part of granting the final order of this writ petition. That's why I am
Yes.
opposing it.
Okay, let notice go at this itself.
And he also
Kindly
not
be
made a
state,
proper
my lord.
party. No, he
State, my
not
lord.
made a proper party.
Otherwise, my lord, this petition has.
Okay, on next date, we will consider your interim pair.
Yes,
In the meantime, you cause service of notice upon private.
private respondent.
But my law is very clear, my lord.
What, yeah, those, what?
Yes, my lord, is my lord, it is not hard, my lord. This order has no meaning, my lord.
Empolita,
Yes, my lord.
learned product. Then also
Oh,
our
who is
Mr.
Review
Supriya, learned.
We elaborate on
Additional
what we do.
senior government secretary, then Mr.
Okay,
Henrik,
okay.
who are also in same capacity,
I am for, but I additional senior government 3 and 4.
384.
My antique color appearing, number 1 and 2.
That's discussing council.
And my submission will be recorded, my lord. He has not made the proper party, appellate authority. It is.
Oh my God, appellate authority, my lord. No, no, that is not necessary, party. My grievance is not for appellate. Appellate authority will follow the law, my lord. I have filed review petition. They will call, my lord. That is not grievance against appellate authority.
This petition under the petitioner has put to challenge the order dated 24/9/2025 issued by the district commissioner Bozalik, by which The petitioner is removed and research from the Sarita Gaugura and all subsequent orders appointing the petitioner as Gaugura of the said search and was with immediate effect. Was immediate. And also the petitioner has challenged the
Challenge the order dated 24/9/2020, case 51.
no, the order passed by the
Director of,
secretary.
yes, my lord.
Page number.
Case number 24, my lord. Director of Land and Service, Land Records and Service,
The
Case 20.
order. Page number.
24, my lord.
Order dated
9,
9/2025.
yes,
And also
9.
the speaking order. Order dated 9
9/9/2025.
September 2025. 2025. By which the Director of Land Record and Survey, Assam, has allowed the appeal referred by Srimati Saruda Talukdar. And the result is dated 2/8/2022 and all subsequent orders appointing the present petitioner as Gauprodan for the said search are set aside and was with immediate effect. There is the petition and the documents plus on record and also for the speaking order dated so and so, and also the order dated so the order dated 24/9/2025 issued by the district commissioner for that. Let notice be issued to the respondent returnable in 2 weeks. State upon the respondent number.
Respondent number 4, my lord.
Respondent number 4 be taken by this.
5, my lord. Sorry, my lord.
Respondent number 5 be taken by registered court with ADN also by the process. Additionally, justice service is also permitted. No formal notice is required to be issued to the respondent number 1 and 4 if they are represented by Mr. Sophia and also by Mr. Hendrik. However, extra requisite copy of the petition be furnished to them during the course of the day. Interim period of the petitioner be considered on next day. Place the matter on 22nd October. Mr. Sophia, you want to take back this?
Oh, yes. There are so many cases of this. I have got a citation, but I will provide you also. Right? All right.
What? 22nd.
My lord, in time orders, my lord.
On that day, it will be done.
Yes. That's my lord, kindly.
Yes, accepted.
Number 31 has lasted.
May it please your lordship, my lord. This petitioner, in fact, is the senior most, but she is deprived from many, my lord, seniority position. Her first appointment, if your lordship kindly take the read petition and the annexure. First, she was appointed in the year 1995 at page 14. At page 14, my lord, she was appointed by the Executive Engineer Dhansiri Project Division Irrigation. That that was on 23/5/2095 to 1995 at page 14. What happened, my lord? Her father was an employee of that department and he expired, and she was, my
Mr.
lord,
Gupta,
given compassionate appointment. Next, my lord, page 17.
No, Mr. Goswami, did
My
you
lord.
file the rejoinder affidavit? To the
Affidavit.
affidavit filed by the respondent? of
Yes,
the
yes.
matter?
I
When?
have filed reply also. To
When?
that. I have filed the reply to that. My lord, he is 10 years junior to me because he joined India 2005 and this petitioner joined in 1995. One order passed by this Honorable High Court, my lord, it is at page, my lord, 31. This petitioner earlier approached this Honorable High Court at page 31. Here, Lordship, she was given with seniority at page 31, my lord. Having regard, last paragraph, having regard to the facts and circumstances of the case, the writ petition is disposed of
Mr.
under
Sophia, you are referring here.
31. 31, I think it is
Education.
irrigation department.
Education, I am not.
Irrigation.
Okay. Irrigation of the state council is there. Irrigation, quite there.
Upadhyay was there, my lord. Today I inform him. He knows, my lord. Only thing is this, my lord. This response number 6. He was also junior, but he is going to retire on 30 September, my lord. Now, response number 7, he was junior, 10 years junior to me. He may become, my lord, head assistant of this department, my lord. How this petitioner can, my lord, work under him? Lordship, there is psychological effect also, my lord, in this entire thing, my lord. So on 30th of
No,
my lord, September.
Swami, you see, this petition was filed in the year
2019. Thereafter, my lord, due to, my lord, COVID, everything, this will remain, my lord, stand still. Anyway, my lord, now because this উপাধ্যায় চিনি পোৱা নেকি? এই আমাৰ ৰুমতে সেই সোমাওতে প্ৰথম টেবুলখন পঢ়ে। আমাৰ তালৈ যাওঁতে এই যে মেইন চাইড তাতে বহে। What happened, my lord? This order of this Honorable High Court 2/12/2006 was passed. The authority shall consider the petitioner for continuation of in service for all purposes, including seniority. This Honorable High Court has given this seniority, and the same order was then, my lord, passed by the executive engineer as page, my lord, 35.
So, Mr. Goswami, on what basis you are submitting that the other respondent is going to be appointed as head assistant?
My lord, because of the seniority list.
Where is that seniority list?
It is, my lord, at page, I have everything and I have challenge. It is under challenge. At page,
In this case, new petition is certain published, Lordship. Forest Master has to challenge this.
So, Mr. Goswami, you have joined as a senior assistant on 1/8/2012,
Yes, sir.
but the private respondent has joined on 19/10/2010. Protection day?
he was, my lord, Khalasi, grade 4 employee. From Khalasi to he, my lord, was promoted to grade 3 post. I was First appointment was my post was LDA grade 3 post. So now he is becoming Milord senior to me because of one order, Milord. I was transferred to Dhansiri of the same Milord department. Milord, this petitioner's mother was thought dead in Milord Udalguri. And this petitioner was so injured in Udalguri. That's why she refused to go there. But in the same department, within the same campus, she took Milord the transfer order with her own interest, with request. Because she cannot go there because her mother was thought dead in front of her, and she was also injured severely, Milord. Now, on that order, the executive engineer passed an order, which is, my lord, I have annexed at page, my lord, executive engineer, chief engineer, my lord.
Lordship, he has to heard the matter entirely, Lordship, and perhaps he has to challenge this impugn Lordship, this new petition list,
No, it is
which has been published on 29/8/25. Unless and until this is challenged, Lordship,
everything, my lord.
case may not, my submission, Lordship.
This petitioner also does not have this knowledge of this, my lord. Yesterday I talked. Everything is suppressed, my lord. This, my lord, one confirmation or order, lordship may kindly produce at page 35. This was also passed in the year 2000, my lord, page 35. Lordship may kindly produce. This was in pursuance of the Honorable High Court's order. At page 35, it was passed by the Executive Engineer, Mongoldoy Division, Irrigation. In pursuance of Honorable High Court's order, CC WPC number 1933 of 2001, dated 15/12/2006, the service in favor of the Tafika Manwara Rahman, Junior Assistant of now Mongoldoy Division, Irrigation, Mongoldoy is hereby regularized for all purposes, including seniority, with effect from 23/5/1995. The pay and allowances, these things are there. As per the Honorable High Court's order, she was given this promotion with effect from 1995. And this Pradip Chandra Day, he joined as Khalasi India 2005, my lord. Now if he becomes, my lord, head assistant, and I have to work under him in...
No, that is a different aspect, but the question is, Pradip Chandra Day joined on 19/10/2010 as senior assistant, and you joined on 1/8/2012.
Now from LDA to, my lord, I was promoted like this. But from the date of joining, this order is passed. His date of joining is 2005. Pradip Chandra Day, it's clearly illegal, my lord. This order, this gradation list is clearly illegal. Till yesterday, I had no knowledge. Just now I have received this copy. Everything was surprised, my lord, from this petitioner.
No, that is a different aspect. But you joined on 1/8/2012, and the private respondent joined on 19/10/2010.
No,
Are you
my lord.
disputing it?
To the post of senior assistant.
Senior assistant, my lord. Because he, my lord, superseded me. That's why he is, my lord, respondent. Respondent number 7.
You have challenged that order.
My lord, no, that order is a recent one. I have no knowledge about this, my lord. Now, what lordship only kindly peruse, my lord, on 30th, this respondent number 6, he was also junior, but he is going to retire on 30th of September, my lord. Now only one thing, lordship. This post of head assistant may kindly be at least reserved for this petitioner, my lord.
No.
Or at least may kindly be, my lord, remain vacant. Because this petitioner worked there at page lordship may kindly be. When this person was, my lord, this respondent number 6 was, my lord, earlier, what happened? He was under disciplinary action, he was suspended. Then this petitioner worked there at page 52, my lord. I had the experience to work as a head assistant at page 52, my lord.
No, that's all right, but you are junior to him. As per this date of joining as senior assistant.
But this order, my lord, we have,
No, forget about this order. You come to the date mentioned there.
my lord, this is order recently passed. No copy was given to me.
Maybe, but the date is mentioned there. You joined on the 1/8/2012 when the private respondent joined on 19/10/2010.
How it can be possible, my lord? He was 10 years junior to me. Maybe a
but,
date of,
You have already.
it may be a
submitted that
clerical
you have
mistake,
been-
my lord.
No, Mr. Goswami, you have already submitted that you have been superseded by him. Whether you have challenged that order,
No, superseded order is not there, my lord.
then
This order is also promotion, this order of 2010 is also not there. Everything was suppressed, my lord, from this petition. At least let this, my lord, post remain vacant, because he has 10 years of next to, my lord, retire, and this petition is going to retire within 4 years, my lord.
no. That is not the ground. That is not the ground. Prima facie, it appears that the petitioner, the private respondent is senior to you in the post of senior assistant.
Now from this, my lord, see, my lord, just now he has handed over lordship before your lordship. Now to get justice, my lord, is it, my lord, proper to hand over like this, my lord?
No.
In the morning also he met me, my lord. He has not handed over, not said anything regarding this, my lord.
Why should he disclose it to you?
No, it is necessary
Disclose
because
it in the court.
no, it's called in the form of affidavit, my lord. They have not filed any affidavit since 2019, my lord. How your lordship can consider just one piece of paper just forwarded to your
No,
lordship?
I am not considering this paper.
That's
I
why,
am
my lord,
considering the
my
date
prayer is
mentioned
this.
there.
I also may not be given to the post of head assistant. He also will not be also given.
These are irrelevant grounds, Mr. Goswami.
But it is clearly injustice to this petitioner, my lord. 10 years junior will become head assistant, and she will work under him, my lord. Clearly injustice, my lord.
From the date of joining, it will be counted.
From the day, why not from the date of joining in the original post, my lord?
You challenge the earlier order.
I will challenge, my lord. Till then, my lord, this post may be reserved.
No prima facie case is in your favor because you are junior to.
This fact just now he has produced before your lordship. Just now I have received. This petitioner is also ignorant. Now earlier I have challenged everything. This earlier, my lord, gradation list at page 42. I have annexed it. At page 42, I have challenged. I am at serial number 6, and this he's at serial number 4. This is from the date of joining. If it is, my lord, quashed, this page 42, this gradation list is quashed, then how this will remain, my lord?
No, from this date also, from the date mentioned here also, he is senior to you.
No, my lord, date of first appointment.
Yes. 4/3/2005.
Yes, my lord,
And
this is-
your is 23rd/8/2005.
Yes.
Who is senior?
No, my date of appointment, your lordship, this one.
Date of joining, you see.
The first appointment, lordship, may first kindly see. 5th date of appointment, 23/5/1995. But he has been given, and his Pradip Chandra day 4/3/2005, 10 years, my lord. I have challenged this. If it goes, my lord, how this will remain? This is just now they have prepared, my lord. How this will remain, my lord?
This is at the time of joining as junior assistant.
Yes, sir.
Since it is this earlier gradation list is under challenge, my lord, this also is, my lord, not tenable in the eye of law, my lord.
No, this.
And they have not filed any affidavit regarding this, my lord. It is 29/8, and today, my lord, about 1 month is to be, my lord, over. They have not filed, not handed over to me, my lord. As because she's a lady and her father, in fact, was in the same department, my lord. Unfortunate date, she became, my lord, she got this compassionate appointment. Now, this executive or engineer's order at page 35, it has been given under as per the order of the Honorable High Court.
Mr. Upadhyay, why you are not filing your affidavit?
Lordship, in fact, Lordship, I was in the under impression, Lordship, he has received the particular gradation list, Lordship, and he has to challenge this list, particular gradation list, Lordship. If I have to file, Lordship, I'll file.
No, Mr. Upadhyay, you see this petition was filed in the year 2019.
We have filed an affidavit, the executive engineer has filed an affidavit, and the private respondent has also filed an affidavit, Lordship.
Yeah.
But I don't know why he is not present today. Affidavit has been filed, Lordship. but-
In their department, in their affidavit, what has been written? Nothing, my lord. Lordship may kindly peruse their
The
affidavit.
affidavit has been filed by the engineer, executive engineer, now.
Yes, he is a party. What he has said. What has said.
Matter be heard after petition.
Who is appearing for the private respondent?
Name was shown in the first, it's shown in the list of. Legal charge.
Shown for affidavit after his order.
So,
Order
Mr.
from the-
Upadhyay, tell the executive engineer not to fill up the post, but we will not pass any order.
Lordship.
But you conveyed a concern of this for that this proposal of this petition. That's the matter we kept back.
I will confirm.
Part submit order. And Mr. Upadhyay, Lord Excellency of the Irrigation
Lordship, irrigation.
Department, non-appears to the respondent part. During the course of hearing, Mr. Upadhyay has produced one gradation list dated 29/8/2025. And perusal of the same indicates that the private respondent, date of joining of the private respondent as senior assistant is 19/10/2010. And the petitioner is 1/8/2012. And as such, it appears that the petitioner is superior to the private respondent number 6. If the date of joining is complete. Date of joining is complete. Under such circumstances, it is provided that Mr. Kusami, learned counsel for the petitioners have obtained instruction with respect to the gradation list dated 29/8/2025 and apprise this court on next data affected. Public that.
Yes.
Part
Yes.
of my part.
Obliged.
Part of. Mr. Kusami,
My lord.
Mr. Upadhyay,
Lord.
there is no written direction as such.
Lordship, I will
But
confirm.
you inform that
Lord.
it could not be filled up. Mr. Kusami, you may obtain instruction.
My lord, it may be in the form that if any appointment is subject to the, my lord,
That can be done also.
result of.
If anybody is promoted, Lordship, that will be subject to the.
Or my lord-
of this petition,
No,
Lordship.
that
No,
can
no,
be
that
done
will-
only
No, my
if,
That will not work, not work. I am sorry, my lord, but same thing, my lord, if he takes the responsibility that the no promotion will be given till at least on 3rd of, my lord, November, then, my lord, in the meantime, I will file affidavit also challenging this, my lord, gradation list.
you will inform, you will inspect.
Lordship.
Because what happened, my lord, one thing is historical first. One civil rule was filed in long back, my lord, in 1996. And one letter was sent by one advocate to the executive engineer. On the basis of that letter, my lord, the appointment letter was of the petitioner was cancelled. Cancelled, my lord. On the basis of, my lord, interim order. Then, my lord, when this civil rule was dismissed, then I was again appointed, my lord. So my harassment from the date of joining, my lord. How and why I don't know, my lord.
And then we will see at the time of.
Obliged, my lord.